यस सर। नमस्ते मनोज जी।
हाँ जी, नमस्ते ममता जी, कैसे हैं आप?
गॉट इट, एब्सोल्युटली गुड, एब्सोल्युटली गुड।
नेहा जी नमस्कार, प्रवीण जी नमस्कार।
हाय
हाय।
नमस्कार सर।
नमस्ते मनोज जी। नमस्ते प्रवीण जी।
नमस्कार, कैसे हैं आप?
सब बढ़िया।
ये प्रवीण जी संडे को भी नहीं आराम से बैठने देते हैं। मैंने इनको बोला क्या करो, स्पेशली जो हमारी वुमेन कलीग है, इनको बहुत काम होता है घर पे, लेकिन कहते नहीं सब लोग मिलकर काम करेंगे। चलिए
सर, काम नहीं करोगे तो जो है लेजीपन आ जाएगा।
प्रवीण जी आप मान के चलो, हम जेंट्स लोग तो घर का कोई काम करते नहीं है,
सर
लेकिन हमारी वुमेन कलीग जो है इनको घर का बहुत काम होता है।
सर घर वालों को करने दो ना।
नहीं ठीक है।
घर वालों को घर का काम करने
चारों को दे हैव, क्या कहते हैं ना, और एक मिला के इनके पास 11 ड्यूटीज होती है। अब ममता जी को भी बुला लेते हो, नेहा जी को भी बुला लेते हो, तो देखो
ये तो है सर।
मनोज जी भी आर ओके। मनोज जी भी आर ओके।
ओके ओके ओके।
ममता जी नेहा जी को देखिए ना, वो जो है डबल ड्यूटी देती है, आप तो सिंगल ड्यूटी दे रहे हो।
चलिए चलिए, जस्ट फॉर द सेक ऑफ फन, चलिए प्लीज।
हाँ, रश्मि जी भी आ गई है। गुड इवनिंग रश्मि जी।
हाँ रश्मि जी, हम आप ही की तारीफ कर रहे थे। यू नो आई वाज फेवरिंग कि मेरी जितनी यानी कि वुमेन कुलीग्स हैं, आप प्रवीण जी संडे को भी इनको बुला के इनसे काम करवा रहे हैं, जबकि इनके पास ऑलरेडी घर का भी काम होता है। एक ही दिन आपको मिलता होगा शायद घर का काम करने के लिए।
मनोज जी इनसे मत कहिए, इन्हीं की वजह से रखा है मैंने आज का संडे।
ममता जी आप सुन रहे हैं या क्या कहते हैं, आप बीच में नहीं हो?
हाँ सर। आई एम देयर।
ग्रेट ग्रेट, चलिए चलिए।
So Parveen ji is the hero of the whole show. Actually.
हाँ जी हाँ जी।
So thank you Parveen ji for all the efforts that you put in.
थैंक यू। हम तो ये देख रहे हैं, हम तो क्या जो है लक्ष्मी और सरस्वती दोनों एक साथ हैं यहाँ पे।
अरे बाप। I personally have to say I'm a great admirer of you.
कॉम्बो है यहाँ पे, कहीं अलग अलग होती हैं बेसिकली तो, बट यहाँ जो है दोनों एक ही है।
What is white is Mr. Parveen, am I visible?
No, sir, your camera is off.
Camera is off. From where? Camera is okay. Rejoin that.
Mukul Sahai ji has also joined us, no?
Yes. Good evening, madam.
Namaste, how are you?
Fine.
Thank you for being there, sir. Thank you.
Thank you, madam. Thank you.
मुकुल जी नमस्कार, वेलकम।
Namaste. Thank you, Manoj ji. Thank you.
Parveen ji,
भी
I
हमारे
think
साथ
in the
थे
next 2 minutes, we can actually, Rashmi, we can kick off the meeting. Because we have the honorable presence of Virendra Gupta ji already. So,
Okay, which we can start the session now, ma'am.
yes, I think in just next 2 minutes at
In
14:05.
next 2 minutes,
you
we'll
must be.
start the session.
Yeah, 16:05 you must be.
16:05. Okay.
Rashmi, yeah, please mute everyone. I think Priya Jain.
I'm meeting. I'm meeting.
गुप्ता जी आज आप कहाँ हैं? बॉम्बे है।
I, Rashmi Chowcharia. We are starting the session, ma'am.
Yes.
I, Rashmi Chowcharia, on behalf of JIPA organization, welcomes you all to the lovely evening of Sunday. In this and today's topic of webinar, as we all know, is insolvency resolution process for personal guarantors. So this is the insolvency resolution of personal guarantors. As we all know that this is a need of the hour, and we are getting many cases allotted by NCLT in Kolkata these days. And now because it is a strict difference from CIP processes, and we are just we need to have much deliberations on this, that how the IP has to go forward in these cases, how the banks have to go forward in these cases. So this is a much needed webinar for today, and I thank JIPA for organizing this, especially Parveen ji. And without wasting much time, because all the speakers and the guest of honors are here, I ask Neha to start the thing. Neha, you can take over now. Neha.
Yes. Thank you, Rashmi. Today, let me first just give a brief introduction about GIPA Professional Association. It's a company which is formed under Section 8, and with the main object, it provides awareness and facilitation service for business, professionals and students in India and abroad. Mr. Praveen Jain is one of the director of GIPA, and CA Ritu Rastogi is the vice chairman of GIPA Professional Association. And today, Mr. Praveen ji and Ritu ji both are with us in this webinar. So I'll just give a brief introduction of Mr. Praveen Kumar Jain. He is a fellow CA and IP. Also, he is a registered valuer. And he has done various courses like certification, like on Master on Business Finance by ICI. Also, FAFD course of ICI. He's a senior partner of Praveen Kumar Jain and Associates. He's also a founder of GIPA Professional Association. He's the director in various company which is providing consultancy service. Ritu ji is a CA and IP, and having more than 25 years of experience in the area of financing, restructuring, revival of SIC industries. She has handled number of cases as an insolvency professional. So with this, I request Mr. Praveen ji to welcome and introduce our chief guest of honor, Honorable Shri Virendra Gupta, who is a formal technical member of NCLT. Mr. Praveen ji, over to you.
Okay, thank you, Neha ji. I welcome to Shri Mukul ji, Dr. Mamta Manani ji, Nipun Singh ji, Manoj Anand ji, Rashmi ji, Neha ji, Ritu ji, and participants. And I also welcome to Shri Virendra Gupta ji and say about something about him. Virendra Gupta ji, 61 years, is an accomplished chartered accountant and legal professional, having rich judicial experience as well. He has completed his tenure as member technical NCLT member on 2nd July 2022. In his distinguished career spanning over 38 years, the journey began as a practicing CA. In 1986, which continued till 2005. During this period, he completed various assignments in the field of auditing, taxation, business advisory services, comprising of techno-commercial, legal, administration projects, corporate restructuring, valuation, designing, and implementation of SOP manual for different business verticals. In October 2001, he was appointed as CEO of Messrs. Jackson International Limited, engaged in operating drilling rigs. During his tenure, the company drilled deepest ever offshore well at that point of time. He also carried out salvage operation, one of the rigs owned by the company in the most trying circumstances. In March 2005, he was appointed as accountant member at ITAT, which position he held till July 2010. As member ITAT, he disposed of approximately 4,000 cases. Sir, 4,000 cases pertaining to direct tax law, and more than 99% of his order had been upheld by higher judicial forms. Approximately 300 orders where he other author or co-author have been reported in all leading tax journals. In July 2010, he started legal consultancy in Mumbai and continued as such till September 2014. During this period, he advised many large clients, including NM Security Private Limited, a leading merchant banker and capital market utility of the country. The area of the consultancy broadly consisted of tax planning, corporate law aspects relating to merger, demerger, and other forms of corporate restructuring and compliance to SEBI regulations. In October 2014, he took a challenging assignment of President and CEO of CMAC Limited, a Mumbai-based listed company engaged in running of BP-DSB in the offshore. The primary task was to transform the company from multinational to family-owned, professionally managed company.
I'm requesting that you could just read one liner for everyone. Because of Virendra Gupta ji's presence and Sahai ji here, I think we should quickly start.
Okay, just a minute.
Just one line.
In July 2019, he assumed charge as member technical national company law tribunal.
Okay, Virendra Gupta ji's profile. Yes, that is fine.
Okay. Over to please experience share and guide your members. Please, sir.
Thank you so much. First of all, I would like to pray to Gajananam Bhoot Galadi Sevitam Kapit Jambu Fal Charu Pakshinam Uma Sutam Shog Vinash Karkam Namami Vigneshwar Pad Pankajam Ya Devi Sarva Bhuteshu Shakti Rupen Sanstita Namastasai 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 Namo Nama Ya Devi Sarva Bhuteshu Buddhi Rupen Sanstita Namastasai 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 Namo Nama Ajnanitimrandhasya Jnananjan Shalakaya Chakshurunmilitam Tasmai Shri Guruve Namaha. Ye pratna, this is the prayer we should get back to as early as possible, because we are not a doer, we are only a means. And without the background and support and energy of the ultimate power, Supreme Soul, we are nothing. We are just like pen. We do whatever the Supreme Soul wants to write through us. With these opening words, I feel my privilege and pleasure to be in company of distinguished professionals, organizations, and participants on a subject which is really having a substantial bearing on the CIRP and liquidation of the corporate debtors, because somewhere it may impact the valuation and the recovery of the debt, as well as on the going concern status of the corporate debtor, directly and both as indirectly. Which everybody is aware that November 2019 these provisions came into force. So without delving upon the background and other things, we have the other speakers and presentations will make all the detailed deliberations and discussions on this. It will be my endeavor to highlight a very few important things which need to be taken into consideration on a broader level. First of all, that is, there are certain controversies which are being settled in this respect, which arose from time to time. And recently, the Supreme Court has settled a major controversy whether proceedings against in personal guarantor can be initiated before initiating the proceedings against the principal borrower of the debtor. So they have relied on section 28. On that basis, it has been held that the proceedings against the personal guarantors can be initiated irrespective of the fact whether any proceedings against the corporate principal borrower are pending or not. This this is based upon the interpretation of the Indian Contract Act 1872. But it's a purely legal position. Nobody can dispute. It is a settled law. But considering the fact that the IBC has got multiple objectives in its preamble, whether it would really be it is a question whether it would be really serving those purposes. Because if the personal guarantor who is not a promoter or who is not connected with the corporate debtor in any ownership way, should he be made liable before such corporate debtor? That's a question. The answer is itself embodied in section 128, which says the subject to the contract, subject to the provisions in the contract. So now it becomes incumbent upon all the participants who are whether surety or guarantor or the principal borrower, so creditor, that to draft the contract to legally bind themselves in such a manner that this liability should not be fastened on the personal guarantor at the first instance before approaching and initiating the proceedings against the principal borrower. Otherwise, it will derail the objective of entrepreneurship development, to promote entrepreneurship, because nobody would come forward to give guarantee and to get itself dragged into a financial obligations. So this is one thing. And another thing is the law needs to be amended because it is 150-year-old law. And when the scale of business or the IBC regulations in this present format were not existing, so suitable changes in the norms is required from both the statutory side as well as RBI to secure that ultimately all the objects of the IBC are met. This is one aspect. Another important aspect is in section 126 of IBC 2000, Indian Contract Act 1872. It states two situations. Contract of a guarantee is a promise to perform or to discharge the liability of a person who on his default. So there are two situations covered. But if we deeply go into the nitty-gritties of the working of this section, then we would notice that no mode of settlement of proper discharge of liability or performance of promise is prescribed, meaning thereby in some cases it was held that the liability of a personal guarantor should be considered only when he is liable to pay to the creditor or the lender. But there is no such prescription in the section itself. So there can be a situation where the personal guarantor, to prevent or to see that the principal borrower discharges its obligations under the contract lender loan agreement, lending arrangement, he may also assist or infuse the funds in the corporate debtor so that default doesn't occur. In my view, that would also suffice the requirement of section 126. So in that sense, it will further secure the lenders. In one sense, the only condition would be such arrangement should be legally enforceable against the principal borrower as well as the personal guarantor. Another aspect which is now settled by interim stay by the Honorable Supreme Court in the Gurmeet Sodhi case recently, that the opportunity of hearing is to be given to the personal guarantor before the IRP or IRP submits its statutory report. So that is also a welcome step, so that at least the personal guarantors get that opportunity. One more important aspect is that recently we have seen a judgment on the NCLT Kolkata bench. The right of subrogation exists in case with due regards, it needs to be seen whether it complies with the requirements of law, in view of the provisions of section 31(1) read with section 238 of IBC 2016, whether right of subrogation that the provision of Contract Act section 140 stands overruled in view of the decisions of the Honorable Supreme Court in Asar Steel as well as in Ghanshyam Mishra, where clean slate is to be offered to the resolution applicant. And one more aspect is that the assignment of guarantee debt whether it can be done even after the approval of resolution plan. In some cases, certainly it will depend. First of all, it will depend on the provisions what the resolution plan consists, as well as certainly if there is no bar, the assignment of guarantee debt can take place even after approval of the resolution plan, because the liability of the corporate debtor under the resolution plan is extinguished, not of the personal guarantors, which is celebrated judgment of SBI versus S. Ramakrishnan, and thereafter in number of Lalit Jain, every judgment has said so. As far as this one more aspect which we need to take into consideration, whether the doctrine of permissible limits of delegated legislation, because what is happening, we are seeing that in many of amendments of substantial nature are being run through changes in the regulations. So that is an area which the government and legislature has to see whether that is permissible and to what extent in the current form of provisions of section 196 bracket 1 bracket T read with section 240, which defines the scope of powers of IBBI. So with these opening remarks, I say once again express my thanks and open the forum for Mr. Praveen Jain to take it forward from this place.
Thank you so much for your kind words. And Neha, please carry on.
Yes, Mr. Praveen. Thank you, sir. So in today's webinar, we have some of the best professionals handling the matter practically. We have Shri Mukul Sahai, GM, Zonal Recovery Center, Punjab National Bank, Dr. Mamta Benani ji, Mr. Nipun Singhvi ji, and Mr. Manoj Anand ji. So with this, we welcome Shri Mukunda Sahai ji, and I'll just give a short introduction of him. Mr. Mukul Sahai ji is the GM of Zonal Recovery Center in PNB, Delhi Zone. He joined OBC in 1993 and worked as a probationary officer. He worked in operations credit recovery in different places like Gujarat, MP, Haryana, Delhi, Punjab. Before working in Delhi Recovery Zone, he handled the recovery and resolution verticals of Amritsar Zone, PNB. So also I welcome Dr. Mamta Benani ji, and she's the National Past President of Institute of Company Secretary. She was a practicing company secretary for over 21 years. She is the first insolvency professional in the country and has handled many insolvency cases. She has bagged so many awards like the Josini Awards and Hello Kolkata Awards. In 2020, she has been confirmed with the Insolvency Law Award winner by the International Advisory Expert. Also, we have advocate and CA, Mr. Nipun Singhvi ji, who is the author of the book RERA, and he's a leading legal practitioner. Also, a CA and IP, Mr. Manoj Kumar Anand ji, who is the president of All India Insolvency Professional Association. I request all of them to take the chair. I also request Dr. Mamta Benani ji to take chair as a chairman for this session and request her to begin the technical session.
Thank you. Yeah, sure.
Go to you. Yeah.
Thank you so much. Thank you. I think with a very, very overall arching session, or maybe if I can say so, it's a dosage of what Mr. Virendra Gupta ji gave us, the Honorable Technical Member. of the Honorable NCLT. I have been very fortunate to actually work under his guidance as such in the court, because he was one person I have seen that who always encouraged, to my knowledge, because as a bar member, as a vice president of the bar, what we always used to see that whether the younger members are coming forward to present their matters. Honorable Virendra Gupta ji was one who always used to encourage those members to come forward, place their deliberations, work on their own brief. Sometimes, people, when they used to just come to take dates, Gupta ji used to say, why don't you have the papers? Why don't you forward your arguments? So I think that has really helped to set the tone of our Honorable NCLTs. And then Gupta ji also, I think, took the mantle forward in Ahmedabad NCLT, where one good thing about Gupta ji, what we have always appreciated in the bar, is he's very particular and specific with his questions and queries. So, may we say many, many things, but he'll just point out that very thing which we don't want to talk about. And he will ask that, please tell me what is it all about this particular point. So you can't just be on a hide and seek mode when Gupta ji is in the chair. So thank you, Gupta ji, for being with us, for guiding us all through. I think the tone that you set with all of us and the guidance that you have given to the generations to come, it will really help the bar to actually raise their levels of argument and even homework. Thank you for that.
Thank you so much. Thank you so much for your kind words.
We had Mr. Sahai yesterday in the IPA meeting also. We had a meeting of IPA yesterday. I think Mr. Sahai actually took us through how the banking norms works. And he was very, very honest to even quip at times that this is something which the larger body has to take care of. But he appreciated the points that got deliberated yesterday. Thank you, Mr. Sahai, to really take out time yesterday also and even today.
Thank you.
It's a mean task. We understand regularly for 2 days, but thank you so much for giving us the honor. And straight away, let's get into the mode of understanding and deep diving in the personal guarantor mode. 2-3 things, and then maybe I'll request, of course, the panelists to get into it. At the outset, let me thank JIPA and especially Mr. Parveen Jain to really organize this so very well and to relentlessly work on achieving the objectives of the organization. Who doesn't know Mr. Nipun Singhvi, and who doesn't know even Mr. Manoj Anand? And all of us are known people at our own rights. Rashmi and Neha, thank you for all the efforts. So as a personal guarantor, I think, when we do insolvency cases, either as an insolvency professional or as an advocate, 1 or 2 things which we have been very careful about is to guide the other side, that is the directors and the suspended board members, that please be vigilant as to what is happening. Sometimes they feel that when they are getting a seat to sit, they feel that it's not required. We don't have any say. We are just there as a mute spectator. But that is not true. They have been given a right to participate. And I'm so fortunate that today I have Mr. Virendra Gupta ji, who will actually correct us if we are just going haywire with our basic understanding. So they are under the definition of a participant. And when we say participant, so they are absolutely eligible in law to participate in the deliberations, but no voting rights has been given to them. So when they deliberate on any issue, they also may like to mention particularly that we would like to get this minutized. Just for an example's sake, if there is a valuation matter which is being deliberated after the resolution plans have come in, and if they have understood that the plan is giving a valuation which is maybe just 100 minus X, which is coming to maybe 1, just for an example's sake. So they should get, and Mr. Manoj Anand and we have been very, very particular to say this, that they should actually get that particular dialect noted in the minutes, that pani ke bhav mein this asset is going away. And this is not true discovery of the price. So it may so happen that even for that matter, because after the resolution plan comes, you can actually talk about and deliberate about the fair value and the liquidation value even in the COC. So the point that we are driving home is they should be vigilant to their rights. They should come at each of the meetings. And when the law is giving you a seat, who are you to just say that, no, nobody listens to us, we are not treated well, etc., etc. Second is, sometimes if the COC tells you to kind of, exit from the room for a while, I think you should be generous and maybe sensitive enough to do that. Okay, so and what we do as insolvency professional, that we write in the minutes that we had requested the director to please give us few minutes, and requested him to recuse himself from this portion of the meeting, so that we are also aware that we had requested him to do so, and he's also aware that he actually left the meeting. In personal guarantee, this, when we talk about PG, especially after the Supreme Court of India's judgment in Lalit Kumar Jain, we realize how important it is that your product, your company should not go away at a throwaway price or at a price which is not genuinely right, because rest of it is falling on our shoulders as a personal guarantor. Number two is that when we used to sign previously as a personal guarantor, we just used to sign like anything like this, because there were so many papers, and we knew that we have to sign it, without which we will not get the disbursement of funds. I request my panelists, esteemed panelists, to please discuss that it is actually said as a continuing guarantee in all the documents that they sign. So what about the limitation law? How is it that you trigger the limitation law, and from what given point in time that you actually trigger it? Whether the bank has to actually invoke the personal guarantee to actually run the limitation period from that particular date, or because of the continuum of the guarantee, by words of continuing guarantee, it will keep on continuing whether we invoke it, not invoke it, etc. And as we move forward, we will talk about it. And the third aspect, maybe I'll request my esteemed panelists to talk about it, is that when a personal guarantor dies, will that liability rest on the survivors in the matter? So as a Hindu Succession Act, we understand that it will fall on the shoulders of the survivor. But as a personal guarantee law, will that prevail or not, is what we were keen to understand. So with my opening remarks, it's though not an opening remarks, it is just to set the ball in motion. I now request the esteemed panelists to start the deliberations, post which we will also have question and answer session. So maybe request Manojji, you would like to begin, and then as a lawyer who actually would like to dissect everything that you have said and everything that he would like to say, we will request Nipunji to come forward there. Yes, Manojji. Please unmute yourself, Manojji. Manojji, unmute yourself.
Sorry, my apology. I could have taken care of it. Thank you, Mamta ji. जब मैं आपको सुन रहा था अभी बैठ के, तो मेरे को ये लग रहा था कि विंदर सर एनसीएलटी की चेयर पे बैठे हुए हैं, और डॉक्टर ममता जी एज एन एडवोकेट इज प्लीडिंग, एंड एट द सेम टाइम वी एज एन आईपी, जैसे जनरली होता है, हम कोर्ट के अंदर खड़े होते हैं, तो वी आर लर्निंग एंड अंडरस्टैंडिंग एंड टीचिंग आल्सो. तो एब्सोल्युटली ओके. अब देखिए, जो पर्सनल कंट्रोल की जो हमारी पूरी सब्सटेंशियल बात है, ये ललित कुमार जैन से स्टार्ट हुआ, फिर महेंद्र कुमार जजोडिया जी के केस के अंदर, एंड अल्टीमेटली गुरमीत सोधी जी के केस में. अगर हम गुरमीत सोधी जी का केस अभी जजमेंट में, जब मेरी डेलिब्रेशन पीपीटी आएगी तो मैं डिटेल में करूंगा, तो इट हैज बेसिकली ब्रॉट एवरीथिंग बैक टू द स्क्वायर वन, जो कि ललित कुमार जी के यहाँ से स्टार्ट हुआ था. अब रही बात, अभी आपने क्या कहते हैं, सर ने एक बड़ी अच्छी बात करी कि जो सेक्शन 196(1) और 240 के अंदर आईबीबीआई के पास को एक पावर दी गई है, whether that particular power is being used properly, or many a time it is being ceded to the court also, for which judiciary and we also have very reservation. सर, ये आईबीबीआई के बारे में जो आज की डेट में ये इन चीजों में ही पावर सीड नहीं कर रहे. we are really हम लोग इस चीज के बहुत जबरदस्त भोग रहे हैं इस बात को कि डिसिप्लिनरी प्रोसीडिंग्स के अंदर भी आईबीबीआई जो है आज की डेट में, यानी कि जो इम्प्लीमेंटेशन है, जो एक हमारे प्रोसीजरल फॉल्ट्स हैं, उनके ऊपर काफी हार्ड स्टांस ले रही है. और जो हम आईपीएस का ग्रुप है, जो हम आईपीएस काम कर रहे हैं, तो एक बहुत बड़ा एक डीमोटिवेटिंग फैक्टर भी हमारे लिए आ रहा है. रीजन फॉर दैट इज कि if you see the average age of an IP, he is around 50 years of age. He has already lived his good life. He is a member of Institute of Chartered Accountants. He is a member of CMA and all these things. What I mean to say is that he is a respectable and reputed person. He will not do anything which is bad or which is intentionally, he will commit some errors or something like that. But IBC is a new law. It has a lot of procedures. और हर बारी आप, मैं डिस्कशन पेपर्स की बात करता हूँ, पिछले 15 दिन के अंदर 10 डिस्कशन पेपर्स अभी की तरफ से आ गए, और इतने फ्रीक्वेंट चेंजेस हैं इन सब चीजों के अंदर, तो उन चीजों को जब हमारी एनसीएलटी की जजमेंट्स है, एनसीएलटी के अंदर रिवर्स हो जाती हैं, उसके बाद सुप्रीम कोर्ट मेनी टाइम्स टेक्स डिफरेंट सॉर्ट ऑफ स्टैंस देयर। व्हाट आई मीन टू से इज दैट कि जब लॉ एक इवॉल्व हो रहा होता है, हार्डली इनको इस लॉ को 5 साल ही होते हैं, तो व्हेन वी एज एन आईपी इसके ऊपर काम करते हैं, तो वी some leniency we deserve to commit any mistake. I tell you, most of the mistakes committed by us are unintentional. It is absolutely, interpretation of a law in the one or the other way. हम एक interpretation करते हैं और आईबीआई दूसरी तरफ से करता है, लेकिन at the end of the day, if we, in the wisdom of IBBI, we are big faulter. हमारा लाइसेंस 3 महीने के लिए, 6 महीने के लिए या 1 साल के लिए कैंसिल कर दिया जाता है। एंड अब यानी यू कैन अंडरस्टैंड, आप भी चार्टर्ड अकाउंटेंट हैं, और बट फॉर यू एस सी इज नॉट अ वेरी बिग डिग्री, बट वी पीपल हु आर सीए, सीएमए, सीएस, दिस इज अ वेरी बिग डिग्री along with IP डिग्री। तो एक जो हमारे इसके ऊपर इस तरह का सस्पेंशन का दाग लग जाता है, तो it really pinches, it not only pinches to that particular person, but it pinches to the whole community। अब अगर हम ऑन दी एवरेज देखें वर्किंग के साथ, अगर हम यहाँ पे 400-500 आईपीएस काम कर रहे हैं, तो जो डिसिप्लिनरी केसेस हैं अप्रोक्सीमेटली 10 to 20% है। तो आई थिंक आई एम एक्सीडिंग माय टाइम फॉर दिस पर्पस, तो दिस इज व्हाट आई मीन टू से। नाउ आई स्टार्ट विद माय प्रेजेंटेशन, जो इस पर्टिकुलर वेबिनार के लिए बनाई गई है। तो प्लीज अलाउ मी टू शेयर माय पीपीटी। प्लीज अलाउ मी टू शेयर माय पीपीटी। निपुण जी, जब तक पीपीटी शेयर अलाउड होती है, आप प्लीज थोड़ा सा कुछ ज्ञान दीजिए हमारे को, सर ने जो कहा उस बात को आगे एक्सटेंड करते हुए।
Thank you, Manoj ji, thank you, Praveen ji, and thank you, Honorable Gupta sir, for accepting our invitation at such a short notice. It is always good to hear Gupta sir, and he is so updated, and he is in true sense a technical member. And thank you, Mamta ji, for setting the ball in motion. तो मेरे पास बहुत ही कुछ ऑब्जर्वेशंस है जो हमने पहले भी डिस्कस की थी एक और वेबिनार में, आनंद जी यहीं जीपा में। सो वन ऑफ द इश्यूज विच आई थिंक मैम ने भी बोला है, जैसे महेंद्र जजोरिया का जजमेंट है, व्हाट आई थिंक, एंड इट इज अगेन माय पर्सनल ओपिनियन, कि सुप्रीम कोर्ट ने उसको डिटेल में नहीं बोला है, एंड दे हैव सेड कि इररेस्पेक्टिव ऑफ कॉर्पोरेट डेटर इज एडमिटेड और नॉट एडमिटेड, फॉर पर्सनल गारंटर द अप्रोप्रिएट फोरम वुड बी एनसीएलटी। सो ये मुझे लगता है कहीं ना कहीं इट्स अ डाइवर्स ओपिनियन, बिकॉज मोस्ट ऑफ द डीआरटी ऑफिसर्स, डीआरटी जजेस, everybody was trained. Many of the petitions across India have been filed with DRT. So again, this is, I think, will again go back to Supreme Court, and in some matter it will be a detailed judgment whether personal guarantor, if the company is not admitted, qua that particular debt and company, that guarantor's admission should take place in NCLT or DRT. So that is one of the mooting points which I request all other panelists to also throw some light, and also request Gupta ji to give some light on this particular issue. Secondly, another issue which I think सभी IPs और सभी प्रोफेशनल्स के सामने आता है, that is with regard to personal guarantors जो बोलते हैं सर हमारे चेक पड़े हैं, चेक बाउंसिंग केसेस हैं. What would happen to the check bouncing cases if personal insolvency is triggered? So again, my view or my interpretation is, if we read the moratorium or interim moratorium, they say all the proceedings with respect to debt. So if we say any legal action or proceeding with respect to debt, in my understanding, 138 cases will also be included. Though 138 cases may, it's a quasi-criminal case, it has a civil impact as well as a criminal impact. But I think so that ultimately debt will get crystallized into money. So probably going forward, this will also help the personal guarantors to start their business again. So personal insolvency route would be advisable to somebody who is facing too many check bouncing cases with regard to financial institutions. So that is my second, I would say, observation. And I request all the panelists to throw some light on this. आनंद जी, अगर आपका co-host हो गया है तो you would like
मेरा co-host हो गया है, I would like to start my PPT. और ये मेरी पीपीटी थोड़ी सी बिफोर आई स्टार्टिंग इट आई मस्ट कन्फेस यू दैट yeah, this PPT, I must confess you, has been prepared by me and ममता जी jointly. तो पहले हमने सोचा था कि कुछ स्लाइड्स ममता जी कर लेंगे, कुछ मैं कर लूंगा, बट व्हेन she was made chairman, तो उन्होंने कहा आप ही स्लाइड्स कर लीजिए. Of the webinar is the practical aspect and recent developments of the law of personal guarantors to corporate debtor. It's a briefly, if you go with the history of insolvency, हिस्ट्री ऑफ इंसॉल्वेंसी जब मैंने थोड़ा सा इसको पढ़ने की कोशिश करी तो इसमें ये पता चला कि हिस्ट्री ऑफ दिवालिया वर्ड इन इंडिया, इन एशियंट इंडिया, इफ अ पर्सन इज नॉट एबल टू पे हिज डेट, then during daytime he will lit diya in his shop, and then the whole market knows that he has become diwaliya. But this person was having no legal sanctity. Just to give legal sanctity, जो हमारा पर्सनल इंसॉल्वेंसी का प्रोसेस था, प्रेसिडेंट इंसॉल्वेंसी एक्ट 1909 और प्रोविडेंशियल इंसॉल्वेंसी एक्ट 1920 came into picture. Now, this acts are still prevailing, but the topic of the today is IBC. Now, Part 3 of IBC 2016 made applicable with effect from December 2019 only for corporate guarantors. It discharges person into of all its past liabilities if he can fresh start his life after bearing pain for around 1 year, theoretically 1 year, but practically अगर हम 180 days insolvency process के initial start करें, फिर उसका bankruptcy का करें, तो it runs into 2 or 3 years. Section 2 of this particular IBC code says that this code shall apply to, by introduction of subsection E, personal guarantor to corporate debtors, it still has to be applied, and it has not been made notified for partnership firms that are partnership firm. तो at present जो है ये एक्ट जो है सिर्फ PG to CD के लिए ही applicable है. These are all the sections and relevant sections which we need to study if we want to practice in personal guarantee. और इसमें एक और अच्छी बात है कि 18/3/2020 से पहले ही हमारा IBC एक्ट J&K पे applicable नहीं था. Now this act is applicable there, meaning thereby that all PG cases can also be done for J&K residents also. These are the big cases. Okay, now let's come out with this thing. Section 94 application. Section 94 application जो इसके अंदर दो तरह की एप्लीकेशन जाती हैं, एक सेक्शन 94 एप्लीकेशन और एक सेक्शन 95 एप्लीकेशन. सेक्शन 94 एप्लीकेशन जाती है पर्सनल गारंटर के थ्रू, whereby he applies to the adjudicating authority for initiation of personal IBC proceedings against it. तो ये जो सेक्शन 94 की एप्लीकेशन जा रही है, ये किन सर्कमस्टांसेस में जाती है? Why I'm sharing this thing with my all audience is that when we act as a consultant to the personal guarantors of corporate debtor, so many a time it is beneficiary for them also to put the application. और जब वो सेक्शन 94 की एप्लीकेशन डालते हैं तो किन सर्कमस्टांसेस में जाती है, या क्या फीचर है उसके, that I'm sharing with you. It has seen practically that in case of corporate debtor where they have given a guarantee and some sort of SARFAESI proceedings, financial creditor or mainly bank has started against them. So we have seen it that just to plan his affair, just to postpone it or get rid of that particular SARFAESI proceedings, whereby as we know everybody we know कि जो भी इसने प्रॉपर्टी मॉर्गेज करी होती है बैंक को एज ए पर्सनल गारंटर टू द सीडी, वो बैंक जो है ऑप्शन के लिए लगा देता है. तो he can file section 94 application whereby because section the moment you file the application आपका एक पार्शियल मोरेटोरियम स्टार्ट हो जाता है, एज रिजल्ट ऑफ विच जो आपकी कोई भी लीगल प्रोसीडिंग्स होती हैं वो स्टॉप हो जाती हैं. सिमिलरली हमने देखा है कि जब भी कोई सरफासी की अगेंस्ट बैंक थोड़ा सा ऑप्शन का नोटिस निकालने लगता है या कुछ और करने लगता है, तो पर्सनल गारंटर टू कॉर्पोरेट डेटर गोज फॉर फाइलिंग सेक्शन 94 एप्लीकेशन. सेकंड सिचुएशन हम लोगों ने ये देखी है कि जो प्रैक्टिकल केसेस हम लोगों ने करे हैं, मेनी अ टाइम्स काफी ह्यूज टैक्स लायबिलिटी आ जाती है, मे बी ड्यू टू द सर्च। और जीएसटी में देखा गया था कि मेनी अ टाइम्स कुछ लोग बिलिंग विलिंग का इलीगल या उल्टा सीधा काम कर लेते हैं, विच दे फील दे वोंट बी एबल टू गेट रिलीफ अंडर दैट पर्टिकुलर एक्ट, maybe under income tax act or maybe under GST or VAT or service tax. So in that case also they file section 94 application to plan their affairs. जब कोरोना वगैरह आया, इस तरह का एपिडेमिक में आया, तो कुछ इंडस्ट्रीज जो हेवीली बोरोड फंड के ऊपर थी, लाइक होटल इंडस्ट्रीज, एयरलाइंस इंडस्ट्रीज, इनका देखा गया कि इनकी दे डिफॉल्टेड इन पेमेंट एंड लाइक दैट। तो इनके जो ओनर्स थे, इन्होंने भी इनका जो इधर सीडी का बिजनेस जब फेल हुआ, तो इनके ओनर्स ने भी, हमने देखा कि प्रैक्टिकली 94 की एप्लीकेशन फाइल करी। एक एस्पेक्ट और देखा गया है कि देखिए कि अगर किसी कॉर्पोरेट डेट पर्सनल गारंटर ऑफ कॉर्पोरेट को पता चलता है कि बैंक सेक्शन 95 की एप्लीकेशन फाइल करने जा रहा है, तो वो ही प्लान्स इज फेयर कि बिफोर बैंक पुट्स हिज एप्लीकेशन, ही पुट्स हिज एप्लीकेशन अंडर सेक्शन 94। इसके अंदर सबसे बड़ा बेनिफिट उसको ये मिलता है, बिकॉज सेक्शन 94 के अंदर हो या सेक्शन 95 के अंदर हो, you can propose the name of the RP. Everybody wants ki instead of dealing with bank's RP, although RP is an independent person, let me deal with person appointed by me. तो इस केसेस में भी देखा है कि they exceed banks and start filing this thing. अब सेक्शन 95 की एप्लीकेशन है, ये जाती है जनरली, नॉट जनरली, ये फाइनेंशियल क्रेडिटर फाइल करता है। तो प्रैक्टिकली हमने ये देखा कि सेक्शन 95 की एप्लीकेशन इन दीज सर्कमस्टांसेस बैंक्स आर फाइलिंग। क्रिप के अंदर ऑलरेडी उनके केसेस चल रहे हैं या चलने वाले हैं, बट दे नो कि जो इनके ओनर्स हैं, जो पर्सनल गारंटर, दे आर मोर वेल्थी। तो क्रिप के अंदर इनका अकाउंट सीडी का जो सीडी का जो अकाउंट था वो एनपीए हो गया या एनपीए होने वाला है। तो उनको लगता है कि हम अगर 95 की एप्लीकेशन अगेंस्ट पर्सनल गारंटर डाल देंगे, so it will put a lot of pressure on them, or that is why bank many a times take decision of doing this thing. Second is that the Ministry of ने सब banks को instruction दी है, including PNB also, SBI also, and other banks also, government was being criticized a lot, where they were being said कि चलिए कॉर्पोरेट डेटर्स को तो आपने आईबीसी के अंदर डाल दिया, लेकिन इनके जो रियल ओनर्स हैं, जो रियल बंदे हैं, जो डायरेक्टर्स या पर्सनल गारंटर्स हैं, दे आर लिविंग किंग साइज लाइफ, उनकी लाइफ के ऊपर कोई फर्क नहीं पड़ा। एंड जस्ट टू टाइटन द अप, मिनिस्ट्री हैज गिवन इंस्ट्रक्शन टू ऑल द बैंक्स, ऑल पब्लिक सेक्टर बैंक्स, कि जिसके अगेंस्ट स्क्रिप्ट की केसेस हुए हैं और जहां पे इन मोस्ट ऑफ द केसेस डायरेक्टर्स की पर्सनल गारंटी ली जाती है, वी शुड try to recover balance amount from them also. जैसा सर ने कहा कि रजिस्ट्रेशन प्लान एक बार अप्रूव हो जाए, उसके बाद उनसे पैसे रिकवर नहीं किए जा सकते एज पर ऑनरेबल सुप्रीम कोर्ट जजमेंट। बट अगर रजिस्ट्रेशन प्लान अप्रूव ही नहीं हुआ, जब प्रोसेस इज गोइंग ऑन, इन दैट केस मनी कैन बी रिकवर्ड फ्रॉम देम। लैंडमार्क जजमेंट में अगर हम देखें तो ललित कुमार जैन जी की सबसे बड़ी जजमेंट थी, जिसके अंदर ये चैलेंज किया गया था कि जो IBC-IP ने नोटिफिकेशन इशू करा है अगेंस्ट पर्सनल गारंटर्स दिसंबर के 2019 के में, दैट वाज चैलेंज, बट ऑनरेबल सुप्रीम कोर्ट हेल्ड अदरवाइज। This judgment has become a little bit old now. I'm not discussing much on it. सर ने भी अभी बताया गुरबीर सोधी वर्सेस यूनियन ऑफ इंडिया, ये एक बहुत अच्छी जजमेंट है। यानी कि ये जजमेंट फ्रॉम पर्सनल गारंटर एंगल से हम देखा थे। तो इस पर्टिकुलर जजमेंट के अंदर ऑनरेबल सुप्रीम कोर्ट ने हार्डली ये एक आधा महीना पहले आई है, तो इस पर्टिकुलर जजमेंट के अंदर आई टेल यू द प्रैक्टिकल एस्पेक्ट व्हाट यू कैन डू। ये क्यों आया है इसको मैं बाद में बताता हूँ। अगर हमारा कुछ कोई हमारे कंसल्टेंसी लेने के लिए आता है, यानी some sort of section 95 proceedings has been started against him, he can move to the Gurbi Sodhi case judgment, and he can tag his case along with this particular judgment and pray to the Supreme Court for the stay of the proceedings against him. Because in this case, what has happened, that Honorable Supreme Court has stayed the proceeding of personal guarantor what are the essential feature of staying this thing, I just shared with you. Sir ने भी थोड़ा सा बताया, तो मैं थोड़ा सा डिटेल में आपका शेयर कर लेता हूँ. It said that moratorium starts on filing his debtor without providing an opportunity to him. So it is the violation of the Article 32 of Constitution कि एक बंदे के अगेंस्ट आप कोई प्रोसीडिंग स्टार्ट कर देते हो और उससे पूछते नहीं हो. और लेकिन ऑनरेबल सुप्रीम कोर्ट ने इस पर्टिकुलर केस के अंदर, गुरमीत सोदी के केस के अंदर ये कहा है कि जो पर्सनल ग्रांटर है, ही विल नॉट एलिनिएट और इनकम्बर और डिस्पोज ऑफ एनी ऑफ हिज एसेट्स. And based on these, three main features, Honorable Supreme Court has granted stay on the Section 95 applications. तो इसको मैंने थोड़ा सा डिटेल में इस करके शेयर करा कि if any of our associates or clients is requiring a stay on the Section 95 application, तो he can tag his case along with it. जैसा कि आपको याद होगा ललित कुमार जैन के केस में शुरू में हुआ था.
Manoj, in this, may you like to just tell the people that whether if they have been given an opportunity of being heard, then probably this case will help them.
ममता जी, इस केस में अपॉर्चुनिटी मिलती नहीं है. रीजन फॉर दैट इज कि आप जब इनिशियल एप्लीकेशन फाइल करते हो फॉर्म ई के अंदर, तो उस समय आप यानी कि यू सिंपली फाइल द एप्लीकेशन, और जो इंटरम मोरेटोरियम है, जैसे ही आपकी वो रजिस्टर के यहाँ पे रिसीव करती है, वो स्टार्ट हो जाता है. तो इसमें तो अपॉर्चुनिटी, और इसी यानी कि बेसिकली मैं एक दूसरे एस्पेक्ट से, जैसे मैंने आपको पहले बताना चाहता हूँ कि आई हैव सीन इन मेनी अ टाइम कि जब सरफासी के अंदर वो ऑप्शन का नोटिस निकाल देते हैं पर्सनल ग्रांटर की प्रॉपर्टी का, तो पर्सनल ग्रांटर इमीडिएटली ये एप्लीकेशन फाइल करके बैंकर को बता देता है कि मैं भैया सेक्शन 94 की मैंने एप्लीकेशन फाइल कर दी है, तो ऑल द केसेस विल बी स्टेट. तो इसी बेस को लेते हुए ऑनरेबल सुप्रीम कोर्ट ने कहा कि इट वायलेट्स फंडामेंटल राइट एज ग्रांटेड टू द सिटीजंस ऑफ इंडिया अंडर आर्टिकल 32, तो हम इसको स्टे करते हैं.
मनोज जी, इसमें मतलब सीआईआरपी एडमिशन नहीं होता है, एडमिशन का नहीं है, फाइलिंग पे ही मतलब ये स्टार्ट हो जाता है मोरेटोरियम पीरियड.
Absolutely.
Yes,
We
yes.
have like CIRP. It's not like CIRP. In personal guarantor, we have two types of moratorium. जो मैं आगे डिस्कस करूंगा, दोनों में क्या फर्क है. तो एक इंटरम मोरेटोरियम होता है, एक फुल मोरेटोरियम होता है. तो ये इंटरम मोरेटोरियम होता है, ये स्टार्ट हो जाता है, और इसका सबसे बड़ा बेनिफिट ये है, सिंपली ऑन फाइलिंग, जैसे रजिस्टर आपको केस आपका बेंच में लगे या ना लगे, जैसे रजिस्टर आपको आप ऑनलाइन फाइलिंग करते हो ना, आई थिंक 2000 रुपया फीस है इसकी, फीस पे करके, और जैसे रजिस्टर अपनी और सीधा आपको कंप्यूटर जनरेटेड काट के देता, उसी टाइम से मोरेटोरियम स्टार्ट हो जाता है. और आपको हर जो भी आपके अगेंस्ट केसेस हैं, जो भी आपके अगेंस्ट रिकवरी प्रोसीडिंग्स है, उनके अगेंस्ट ऑटोमेटिकली आपको स्टे मिल जाता है.
Manoj ji, we have the esteemed presence of Shri Gupta ji.
Sir, yes. Sir, please enlighten us. Please enlighten us.
This is the interim moratorium is applicable since the moment application is filed and given in numbered in that sense, as against the section 14 and in the case of normal CIRP. And a final moratorium will come after the statutory report and recommendation of the RP is accepted by the adjudicating authority.
Yes, sir. Yes, sir.
There is no, and in both these stages, the situation is whether the opportunity of being heard is to be given to the affected party or not. That is the question. That was the question. Some NCLEC, in some cases, earlier had some NCLT benches had a view that limited opportunities to be given, like Section 7 as held by the Honorable Supreme Court in the case of Swiss Stevens. On the same analogy, now it has been expanded in the case of Gurumeet Sodhi. The opportunity of hearing in terms of Section 424 of Companies Act also, where the principles of natural justice are binding on the adjudicating authority, being NCLT. So these are the situations where we have to take into consideration, and moratorium will certainly come into place the moment application is filed.
Sir, I would like to add one more writ petition which is now filed in Gujarat High Court. In that case, it was a section 95 moved through RP.
Through RP. Normally, through RP, all the financial creditors are moving through RP only.
So in that, the point of principle of natural justice, they have said that since RP has filed an application, and in normal course, the view is courts ask the RP to give a report. Since he has already filed the application, he has already formed a view. So ultimately, it's a violation of natural justice in a way that the person who was going to judge whether this case has to be admitted or not, he himself has done it.
Yes,
Therefore-
that is correct, but that is correct. But there are exceptions to the this system of applicability of principles of natural justice. Generally, principles of natural justice are not applicable when there is a bias. But if some bias is created by a statute itself, so that bias can that will not be considered as a violation of principles of natural justice in that sense.
I
is
think
why-
that also is now going to Supreme Court.
Yes,
Here,
then
Gujarat High Court
if
has
you
issued-
recall,
Yes, sir.
I think all the professionals must have gone through the recent order with the Allah bench, which I was the author of that, in the Rati graphics, which has been pronounced on 13 June 2022 itself. We have taken a view of whether the principles of natural justice are applicable to IBC proceedings or not. And we have formed a view, we have held that the principles of natural justice in all its dimensions, subject to statutory exceptions, which are already there, because there is a statutory exception of COC, which is there is a apparent conflict of interest, there is a bias for them, and their actions are non-justiciable. So they are supposed to act more in following the principles of natural justice. And in that case, we have also held that the principles of natural justice will be considered as a law having force for the purposes of section 30 bracket में 2 bracket में clause E, so that any arbitrary and capricious exercise by the COC shall certainly can be set aside, examined, and any decision which has caused prejudice to any person who is having a substantial cause of action and locus shall have to be revisited. That is the which we in the facts of the case we also held that. So now this issue is becoming, even if you see that the discussion paper which was floated by IBBI in August 2021, it dealt with the same issue, the conduct and arbitrariness of the COC. Or to be very frank, except in Swiss Reven's case, where certain provisions were challenged on the basis of constitutional validity, we have not seen, in fact, any challenge as a whole to the constitutionality of IBC 2016, which violates principles of natural justice in all its ramifications in a flagrant manner. Because you don't give opportunity, limited opportunity, and if proceedings in RAM, not in personam, recent and judicial view is also the same. If you see, there is another decision of the Supreme Court has come where they have said section 60 subsection 6 of IBC, the moratorium will be applicable for the purpose of extension of limitation to the corporate debtor under the new management. Whereas in the SR Steel case, the Supreme Court has said the all claims stand extinguished and section 60 subsection 6 benefit will not be applicable after the resolution to any claimant or the creditors. So there is dichotomy between the approach of the Supreme Court itself. Once you give a right to the corporate debtor under the new management to recover its dues, having the benefit of extended limitation period by resorting to section 60 subsection 6 of IBC, the same benefit you deny to an operational creditor or financial creditor who has. So there has to be something looked into statutorily, and as well as judicial approach is also required to be remodeled. So on the basis of arbitrariness or capricious exercise or violation of principles of natural justice, we have to see. It has to test the time by at the highest forum of this country, judicial forum at the Honorable Supreme Court. And in fact, you say there is a decision of Bilal RCPK, dated 3rd June 2022 by Honorable Supreme Court. While deciding section 12A issue, they have extended the same principle which was evolved in the case of Swiss Revens, where the power was given to NCLT and NCLET that they can set aside any decision which is a stance of arbitrary, capricious or malified exercise by COC. And we have also had in that view for the benefit of IPs and other professionals, that whether any IP acting as a IRP or RP or liquidator, they are public authorities discharging public functions. So they are bound to follow the principles of natural justice in toto, except whatever exceptions, 2 exceptions are there, COC has become. So this is the hot issue which is being deliberated everywhere. Government is to look into it, whether the person who is going to be affected deserves a right of hearing or not at all. That is the situation right now.
थैंक यू वेरी मच सर, आपने बहुत अच्छी तरह से एनलाइटन करा, बहुत ही अच्छी तरह से एनलाइटन करा। यानी कि ममता जी, प्लीज से समथिंग, यू वांट टू से समथिंग, प्लीज कैरी ऑन।
थैंक यू वीरेंद्र जी।
थैंक यू वेरी मच। देखिए, अब सर ने जो बात कही, इसको मैं समराइज इस तरह से कर देता हूँ विद रेफरेंस टू गुरमोह सोधीज केस। इसके जैसे कि मैंने पहले शेयर करा कि जैसे ही हम लोग एप्लीकेशन फाइल करते हैं तो इंटरम मोरेटोरियम स्टार्ट हो जाता है। तो इंटरम, जब इस केस के अंदर जो आर्गुमेंट्स दिए गए थे एडवोकेट से, वो ये दिए गए थे कि जैसे ही हमारे यानी कि क्लाइंट के अगेंस्ट ये एप्लीकेशन फाइल करेगी, उसकी रेपुटेशन डाउन हो गई, ही बिकेम इन फाइनेंशियल स्टेट, बिकॉज लोगों ने कहा कि इसके अगेंस्ट आईबीसी प्रोसीडिंग स्टार्ट हो गई है, दिस इज ऑल दिस थिंग। और ये जो यानी कि जो सिस्टम स्टार्ट हुआ, ये बगैर उसको हेयर किए हुआ, बिकॉज एप्लीकेशन तो आरपी साइन करके करे जाना करे, 94 के अंदर डिस्कशन है एप्लीकेंट की, तो अगर उसके थ्रू करी गई तो एकदम जब ये स्टार्ट हो गया तो इट पहले हम लोगों ने बेनिफिट काउंट करे कि 94 के एप्लीकेशन में क्या बेनिफिट है। इस केस में एडवोकेट्स ने ये कहा कि इसके एप्लीकेशन फाइल करने से क्या नुकसान हो रहे हैं मेरे क्लाइंट को, तो एज अ रिजल्ट ऑफ इट दिस एप्लीकेशन जो है, जो कि मेरे क्लाइंट के अगेंस्ट फाइल करेगी विदाउट हेयरिंग मी, इट शुड बी स्टॉप, and because it violates Article 32, and Honorable Supreme Court agreed with the condition of the concerned advocate, and they granted stay against the proceeding under Section 94. And the advocate सर ने भी ये कहा कि वो गुजरात हाई कोर्ट के अंदर भी रिपोर्ट के रिलेटेड जो है, सर आप बिल्कुल ठीक कह रहे हैं निपुण जी, कि देखिए जब मैंने भी रिपोर्ट फाइल करी, अब देखिए 2 चीजें बड़ी कंफ्लिक्टिंग आ रही हैं। एक, मैंने यानी कि आप ही का बात को आगे एक्सटेंड करते हो, जब मैंने एप्लीकेशन साइन करी, मेरे को किसी ने अपॉइंट करा, प्रपोज करा आरपी, तो चाहे सेक्शन 94 की एप्लीकेशन हो या 95 की एप्लीकेशन हो, जब मेरे को उन्होंने आरपी प्रपोज करा तो मैंने वो एप्लीकेशन साइन करी। अब मैंने एक चीज को आइडेंटिफाई कर दिया जब एप्लीकेशन साइन करा, अब उसके बाद मैं उसकी रिपोर्ट क्या दूंगा बाद में सेक्शन 98 के अंदर, सॉरी सेक्शन 99 के अंदर। तो this is conflicting there, but only thing is we said that law is evolving, नया लॉ है, तो धीरे धीरे इसके अंदर कुछ ना कुछ चेंजेस आके, जो भी ये आगे भी बहुत सारे इश्यूज हैं, जैसे सीओसी की सर बात कर रहे थे, अब सीओसी की कमर्शियल विजडम को सुप्रीम कोर्ट ने ऐसे लिया है कि जैसे जुडिशरी कुछ है ही नहीं, यानी कि वो जो काम करती है वो दैट जुडिशरी कांट इंटरफेयर। तो ऑनरेबल सुप्रीम कोर्ट का इट्स इन देयर विजडम they have taken this evolved law in this way, so this is all there.
Now for the benefit of all the users, please read para 153 of that order, last page of our order, that addresses so many issues on the broader policy front, and in that the functioning of COC has been duly highlighted, and it is to protect the IPs, because neutrality and independence of the IPs is compromised. Theoretically we may say anything, but the professional interests have to be taken care of also. You see, section regulation 35 sub regulation 2, we were of the CIRP regulations, which is under chapter 10 of the CIRP regulations under the head of resolution plan. So, and as per that, if we go by that regulation, the fair value and liquidation value should be known to the COC only when the resolution plans are received. This is the scheme, but whether in reality it happens, that is a question. So the position of RP has been very, very strong, though it may be termed as a facilitator or administrator. It's not that the statute has given enough powers, but the pressure of COC functioning and their advocacy, as Mr. Manoj has already pointed out, the commercial wisdom has been made non-justiciable for, and in the garb of that, they try to become and serve every function according to whims and fancies of their own members. They try to function. That's the real problem created and coming from that end.
My due apology to Mr. Mukul Sahib because he is from the COC side. So, but sir, ये एक the mutual discussion है, तो I hope he will take it in good spirit. So,
Then we
thank you
would
very
like
much,
to
sir.
be enlightened, because it is the way it is, since NPAs and other issues are affecting this country as a whole, and they are also suffering. So we have to take. We are not saying personally, but what is happening as a adjudicating authority, what we observed during the course of our adjudication processes. This was the feeling that is we expressed in our order. We can't speak now. I'm not a member, so now I'm a free bird. I can express my view on the public forum, but otherwise as a member only we can speak through our judicial orders. So that was the attempt, with all good intentions, to explain that
Yes, sir.
his principles of natural justice
Mr.
is made
Sahai, would you
applicable
like
to
to say
IBC
something?
I think,
proceedings.
yeah, sir. इसमें if my colleagues permit me, can I ask for one question, please?
Yes,
Manoj,
please.
सर हमारा देखिए, अगर हम आईबीसी में एक सिंगल रीजन लेना, यानी कि आईबीसी का जितनी इफेक्टिव वैसे ये हो सकता था, हो नहीं रहा, उसका सबसे बड़ा रीजन सर ये है, माय ड्यू अपॉलॉजी फॉर दैट, आई एम यूजिंग माय वर्ड ड्यू अपॉलॉजी फॉर दैट अगेन एंड अगेन, जुडिशरी की तरफ से जो जजमेंट्स की डिले होती है सर, आपके लिए
Yes.
सरकार ने, सॉरी कोर्ट ने कह दिया कि सारी की सारी टाइमलाइन डायरेक्टली इन नेचर है, हमारे लिए सर कह दिया मैंडेटरी नेचर, तो सर जरा प्लीज इस पे भी हमारे दिल थोड़ा सा बढ़ाइए और थोड़ा सा हमारे को
I fully agree with you and endorse your observations, because there is a section 64 of IBC which says the expeditial disposal of cases, and you may note down. Section 64 says there perhaps subsection 2, expedition within the certain time of hearing we have to dispose of the cases. But you have to see from two perspectives. In last 3 years, what has happened? There was pandemic situation, number one. I'm not trying to explain the position, but I will tell you the reality. And number two, members, there was no regular president till to October 2021 for more than almost 2 years. Members were not appointed. Every member was taking 3 or 2 or 4 benches. So there is no regular staff, even contractual. Now the government is trying to bring the regular staff. So this is the forum which you have to take. And in fact, as far as our bench is concerned, whether be it in Kolkata, Mamtaj is there, Mr. Nupin is there, where I was member, there was a question, 7 to 10 working days. All the decisions were pronounced from the date of hearing of the order. We disposed of 2,000 cases in Ahmedabad, 1,400, 1,500 cases in Kolkata. So it's not that members are 80-20 principle works everywhere. 20% people carry 80% works, 80% take 20% work. Even in judiciary, that applies. So there is only one thing that can be done, and the role of the advocates is also there. They conveniently try to take adjournments on personal grounds, and Supreme Court has also come heavily on that. Filing of the role of the bar is very important. The Roger Matthew case, in the Roger Matthew case, the Supreme but the South Indian Bank, the Supreme Court has the Honorable Justice Chanchud Sahab has clearly stated. Now the bar and the professional fraternity has to come up with the expectations of the society, instead of making a case of professional enrichment at the cost of justice and delay. That should also be. Frivolous applications are filed. Section 19(2) is a ritual. The moment an IP takes a charge, within a month you get a Section 19(2). So these are the cases where we have multiple factors, and I agree with you. But these are all the aspects or the different issues taken together. And another aspect is there: no rules under IBC. Timelines you have mentioned, starting from Swiss revenge. If you go by strictly by the principles the IBC, limited opportunity within 40 days, Section 7, admit, date and default, nothing to be seen. In Section 9, only one opportunity, before that too, before filing application, notice of demand. That's sufficient. But in spite of that, Honorable Supreme Court held that, no, opportunity to an effect, going to be which is going to affect certain parties to be given. So separate rules are required for IBC proceedings, where the adjournment should not be given, where there should be a direction for the members to dispose of the matters. There should be a mechanism of monitoring of case management by the administration strictly. Who reserved the order, what reserved, when it was drafted, when it was sent to the member, other member, when it was signed, why it was not pronounced. All these actions are required at all levels. We do, it's not that, but we have to take into consideration there must be cost for adjournments, filing. Now the 1 crore limit, the basic structure happened, the 1 lakh limit, it overburdened the IBC. But we are not concerned, NCLT, sorry. We are not concerned with the fate of the company petitions. We are not even talking about that. It's a very sad state of affairs. The whole economic growth is suffering because of reorganization and restructuring is pending for 2 to 3, 4 years, 5 years, 6 years. So we have to, professionals have to take, you can take a better standing and a better forceful representation to the government, executive as well as legislature to redesign the law, so that the delay is altogether can be controlled in a larger public interest.
Thank you, sir. Thank you so much.
थैंक यू सर, थैंक। आई थिंक इस चीज को मैं एक ही बात से कंक्लूड करूंगा कि IBBI is coming out with lot of discussion papers. They should come on discussion paper on this also कि you know de-skilling IBC, and सर ने इतनी सारी बातें बताई कि उस डिस्कशन पेपर में क्या क्या पार्ट हो सकता है और कैसे कैसे उस चीज को खत्म किया जा सकता है। थैंक यू वेरी मच सर। सर वी आर रियली elated with your deliberation. Thank you very much.
नहीं, it is because in the interest of the company. देखिए, there is one saying, in the good of the society, your best is involved. In the bad of the society, your worst is involved. It is that relative degree. So you see, chain of bankruptcies are happening because of nothing is given to operational data. We can go on and find out so many things which are happening. Let the good sense prevail. Let us come back to the issue.
May I move forward now, please? With the kind permission of everybody.
Please,
Okay.
please.
Yeah. Next important judgment which has already been discussed was with reference to Mahinder Kumar Jadodia versus SBI, whereby NCLAT held that even in the absence of any pending corporate insolvency proceeding or liquidation proceeding, application under Section 95 can be made against the personal control of the corporate debtor by virtue of Section 61 Code. और इसके अंदर जो टेरिटोरियल जुरिडिक्शन थी वो भी ये कहा गया कि जहां पे रजिस्टर्ड ऑफिस सीडी का है वहीं पे उसकी टेरिटोरियल जुरिडिक्शन आएगी। सिंघी सर ने थोड़ा सा इस पे हाईलाइट करने की कोशिश करी कि डीआरटी के जजेस में वो का बारे में जो है, तो सर आई फुली डोज योर व्यू, और इसके लिए अगर आप कुछ और ऐड करना चाहे तो प्लीज ऐड करिए।
सर मेरा यही व्यू है कि शायद ये जजमेंट सुप्रीम कोर्ट ने रीजनड नहीं दिया है। दे हैव जस्ट सेड दैट वी विल नॉट इंटरफेयर विद द जजमेंट ऑफ NCLAT। सो मुझे लगता है कि जब ये रीजनड ऑर्डर होगा, ये पर इंक्यूरियम है, एंड व्हेन इट विल बी रीजनड ऑर्डर प्रोबेबली सुप्रीम कोर्ट विल एनालाइज कि व्हाई इफ द मैटर इज नॉट एडमिटेड jurisdiction of NCLT does not lie, it should continue with DRT. Otherwise the procedure and the notification of Ministry of Finance goes away.
Yes.
In my opinion, Nipunji, when this came, I was totally opposite to, I mean, when I was being suggested with, I was giving a contrary view to what has come.
Yes.
There are another two aspects. We have to understand what the judiciary and the they are thinking. If you see Section 5, bracket में 5 capital A of IBC, corporate guarantor. There was a decision even to an corporate guarantor, to an individual or to a proprietorship firm or to a partnership is liable to be initiation of insolvency under IBC. And 60 subsection 2 is very clear, but 60 subsection 1 has been given a predominance. So there is a question of reconciliation between the two sections. My personal view is also same, कि unless something is pending against you, against the corporate debtor, it should not, that is based on equity also. Not though we say equity is not applicable, but it is unless there is some action against the principal borrower being a corporate entity, how you can assert the jurisdiction of DRT in both ways. Or in the corporate person, we corporate guarantor we can understand, because the corporate guarantor is a corporate person in terms of provisions of IBC, in case of even in case of individuals. So some rebalancing is required, whether the individual is connected in either as a personal guarantor or as a principal borrower. Who should have the jurisdiction? This issue will have to be resolved one or the other day.
सर बिल्कुल वही बात कर रहे हैं जो निपुण जी ने कही, एंड जो स्टार्टिंग में मैडम ने, ममता जी ने जो बात की कि जब बेसिकली हो ये रहा है कि जब एक्ट बनाया जाता है बेस्ड ऑन सम रिपोर्ट, एंड जैसे BLRC रिपोर्ट या पर्सनल कंट्रोल के ऊपर भी कमेटी बैठाई गई थी, वो ऑब्जेक्टिव्स को एनालाइज करके किया जाता है, बट परहैप्स बिकॉज ऑफ एनी रीजन लेटर ऑन इसकी जो इंटरप्रिटेशन आती है जुडिशरी से, वो शायद जो इसका ये बेसिक ऑब्जेक्टिव होता है उसको शायद थोड़ा सा ओवरलुक कर दिया जाता है, जब मे बी बिकॉज ऑफ एनी रीजन इट चेंज्ड. तो चलिए मैं थोड़ा सा आगे और बढ़ता हूँ.
Just one point to be considered close here.
Please.
Successor. Normally, what it will depend on the terms of agreement for guarantee contract or guarantee, number one. But there is the opportunity under general law will not be deprived against the successors. But now, however, NCLT Kolkata bench has taken a view in one case that as successors of personal guarantors do not fit into the definition what is of given the guarantors of the IBC, hence no recourse under IBC can be taken against the successors. Though the general opportunity to avail the remedies under general provisions of law will remain there, subject to the terms of the contract of guarantee.
Now, what
So,
I understand. Yes, please. Yes, Mamta ji, please.
Yeah, I was asking Gupta ji. Gupta ji, what is your view? Will it come to the successor or it will not, sir?
Under IBC, I am of the view it will not come. My view is that it will not come under IBC successor ke liye, under the present statutory framework. But under the other law, it can come.
Sir, इसमें what I understand is that under general law, अगर आ भी गया successor के पास में, let's see, presume it hypothetically, तो उसकी liability will be limited to the extent of the property which he is getting as a successor.
That is another question, whether his personal property is not connected with the not related to succession, whether that would come or not. That is another dimension of this situation. So and how the moratorium will be applied to such successor, because interim moratorium comes, so he cannot dispose of his personal properties also.
Yes, sir. But I remember in taxation laws, in income tax laws, if any liability is of any any individual is devolved to the successor, then it is absolutely devolved only to the extent of what he gets from that particular succession.
Under income tax, there is another aspect. If you take the property or something, capital gain, but it is a legacy, so that is not taxable as such in your hands also. If something is you get a legacy, though it may be taxable and on the original SSC, but if some successor gets as a legacy, as a inheritance, so that would not be taxable. Just for example, capital gains. Somebody invests in the bonds or capital schemes. So, but in the meantime, the original SSC is dead, and you'll get the benefit of that interest or something. That capital gain which you have availed exemption cannot be withdrawn because it is a legacy, not anything. You are not liable to capital gain.
Yes, sir. Thank you very much. Thank you. Let me move forward, because time is also a bit constrained for us.
Time is
Okay, now I'm taking up some practical questions and answers, and my first question is, I thought of asking my answer to my co-panelists and other the person, the other attendees also, but since scarcity of time, it's already 5:20. What answer I have in my mind, I'm sharing with it. एंड इसके अलावा अगर कोई और आंसर हमारे को पैनलिस्ट या हमारे लिसनर्स के पास हो तो प्लीज ही कैन शेयर इट विद मी. This is absolutely what I have learned from my practical experience and other things. Prerequisite for filing application 95 by a creditor. You have to check the limitation because documentary evidence of guarantee in legible form of should also be checked. You have to issue the demand notice, appoint RP, and give all available things there. If no CRP, can proceeding under PG to CD be started? इसका already yes हमने बोल दिया. Section 2 very clearly says if proceedings are going on at DRT, can petition against him be filed in NCLT? Yes, if he is a PG. If CRP proceedings are going on at different places, तो अगर this is quite possible कि एक PG ने गारंटी दे रखी है डिफरेंट कंपनीज की और उसकी डिफरेंट कंपनीज की अलग अलग जगह पे CRP चल रही है, तो किस केस पे ज्यूरिडिक्शन में इसका करा जाएगा. तो इसमें डोमिनेटिंग व्यू यही आ रहा है कि जहां पे वो डेटर द पर्सनल गारंटर रह रहा है वहीं पे. इफ मेनी एप्लीकेशन आई हैव आंसर्ड दिस थिंग. Yeah, one is can same RP be appointed for more than one personal guarantors of same CD? Now it is a yes, and courts are also accepting it, and in fact it's a cost effective also. In one of my case, for a particular CD, I was appointed as RP for 5 personal guarantors. If a partner director from an IP is RP of CD, can he be appointed as RP a personal guarantor? सर इस पे थोड़ा सा कंट्रोवर्शियल इशू है. जो मेरे पास आंसर है वो मैं आपके साथ शेयर कर देता हूँ. आगे सर आप बता दिए. आई रिपीट, दिस इज अ वेरी मटीरियल क्वेश्चन. प्रैक्टिकली व्हाट हैपन इज दैट कि अगर एक आईपी के पास सीआरपी का केस है तो वो यही चाहेगा कि उसका जो दूसरा पार्टनर या डायरेक्टर है उसके पास पर्सनल गारंटर का केस चला जाए. तो डू लॉ प्रोवाइड अस दैट फैसिलिटी और नॉट? तो दिस इज अ क्वेश्चन. और जो इसके बाद मेरा आंसर है सर, आप और बाकी पैनलिस्ट भी मेरे को इंप्रूव कर सकते हैं. If a partner director from an IP is RP of CD, can he be appointed as RP of personal guarantor? सर ये इसमें तो ना है. Sorry, this was not my question. ये तो रेगुलेशन 3 के अंदर क्लियर लिखा हुआ है. ये this was a question which required a little bit of thought and debate. If a partner director from an IP is RP of CD, can the other partner director be appointed as RP of personal guarantor? तो जो मेरी लिमिटेड नॉलेज है, जो मैंने थोड़ा सा R&D करा है, उसके मेरे अकॉर्डिंगली yes, because there is no specific exclusion except as per regulation 4, which restricts his appointment as he is representing any party in registration process. कहने का मतलब यह है कि रेगुलेशन 4 ये कहता है कि जो भी आप आरपी अपॉइंट कर रहे हैं उसका कुछ इंटरेस्ट नहीं होना चाहिए जो भी सीडी का के साथ, सॉरी सीडी के साथ नहीं, जैसे रेजिडेंट एप्लीकेंट है उसके साथ उसका कुछ लिंकेज नहीं होना चाहिए. तो इस करके इट डज नॉट हिंडर अगर एक आईपी का डायरेक्टर जो ऑलरेडी सीआरपी प्रोसेस कर रहा है, दूसरा डायरेक्टर अगर आरपी उसका अपॉइंट हो जाता है. सर इस पे जरा प्लीज थोड़ा सा कंट्रोवर्शियल है, प्लीज एनलाइटन करें.
It is a apparent conflict of interest because you are working under same umbrella, and if one party is looking after one aspect which is correlated, very much interwoven, CD's valuation, CD's resolution, CD's liquidation versus personal liability of the guarantors, they are very much correlated. There cannot be double dip, but there has to be recovery to the extent what is not recovered from the CD. So there is an apparent conflict of interest between of the same person, and if there is no provision, it should be treated as a part of ethical professional requirement that we should not try to be part of that. We should recuse from that assignment just to maintain the highest standards and set an example. Otherwise, the allegations of impropriety can come at, and that would be there by any frivolous application. For that ground will also be filed with the adjudicating authority. If they had a conflict of interest, they were they were part of the same organization and still they took the contrary positions. Conflict.
Thank you very much, sir. Thank you very much.
This is my personal view.
No, sir, I resonate with your view, sir. Absolutely.
Thank you very much. You know, this is absolutely yes what I said. Thank you very much for enlightening. Limitation applicability from the date of execution of papers or from the date of revocation of guarantee.
No, invocation. It should be invocation of guarantee.
Yeah.
Invocation of guarantee.
Yeah, invocation of guarantee. Yes, yes.
Yes, yes. It would be from, normally it would be from the date of invocation of guarantee and subject to any period is given in that invocation notice. Then on the expiry of that time, the debt will become due and payable.
Thank you very much. This way, I have already answered where to file the application. Honorable Supreme Court has made very clear all personal guarantee application has to go to the NCLT only, nothing with the DRT. Okay, sir, ये भी आपने थोड़ा सा ले लिया था. Can PG recover amount from CD later on payments made by the creditor? तो जो इसके बारे में जो मेरी limited knowledge है, according to that, as per Contract Act under Section 145, there is an implied promise to indemnify surety by the borrower for all rightful sums paid under the contract of guarantee. But Section 31 of IBC says approval of resolution plan is absolute and binding on all, including PG to CG. In that case, sums paid shall not be rightful and PG shall not be entitled to indemnify from the CD. So
that's very clear in the Lalit Kumar Jain. The Honorable Supreme Court has clarified this aspect that the resolution plan, under the resolution plan approval process, the liability is extinguished because of operation of law. That is Section 31(1). And in,
yes, sir.
And not otherwise, not a contractual or any act or of omission or commission or variation of terms of contract between the parties without notice to the personal guarantor. So in that sense, this right of subrogation doesn't remain there, except there could be a situation only in resolution plan if you provide get the right to of the creditor will the personal guarantor will still survive, and to what extent only, because it all depends upon, normally all resolution plan provide for extinguishment of all liabilities of personal guarantors to recover from the corporate debtor under new management subsequently.
सर प्रैक्टिकली मैं थोड़ा सा शेयर करूंगा. हम लोगों ने जितने केसेस करे हैं उस केस में नई पार्टी होती है जो नया रेजिडेंट एप्लीकेंट है, और सीओसी होती है ये फाइनेंशियल क्रेडिटर्स की. तो दे से कि हमारा कुछ लेन देन नहीं है, जो पर्सनल कंट्रोलर है या जो डायरेक्टर है, तो इस करके आप रेजिस्ट्रेशन प्लान के अंदर आप कभी भी आपको ये लिबर्टी नहीं देंगे कि आप पर्सनल कंट्रोल की लायबिलिटीज को जीरो करें.
they say it will remain there, na? That is what
yeah they say it is remain there,
and it is one of the reasons with due regards that the COC sometimes get carried away with the undervaluation or early liquidation of the corporate debtor, because they have got a cushion of personal guarantors and their assets for recovery of their dues. That is what is our experience in some cases.
Yes sir. I think I'm moving a little bit fast now. Application filing date कब से applicable होगा आपने already discuss कर लिया. Default amount sir surprisingly is still 1,000 rupees, and एक तरफ 1,000 रुपए और एक तरफ 1 करोड़ रुपए है. If we see something like that, it's a really astonishing.
Let it be put up. Actually, what we request in the earlier conferences also, Mr. Nipun will recall, when we had occasions. So what is happening? We are not a participative professionals in the legislative process. Though consultation by IBBI is a good step because this is the requirement of the statute. But we should try to bring the anomalies and unintentional mistakes or gaps in a statute to the legislature by way of our representations from time to time. At least a time will come when they will take a call on that.
Sir, हमारे निपुण जी, हमारी ममता जी and other our members also, they are very keen to help IBBI. You try to understand. देखिए जो IBC का अगर 4 pillars है, 4 pillar में से एक IP को भी एक pillar माना गया है, तो एक अगर लेकिन जो ये pillar है ना, इस pillar से बाकी pillars बनते हैं. that aspect has to be realized by the IBBI and the judiciary and advocates also, because एक जब IBC का काम स्टार्ट होता है तो मेन जो रिस्पॉन्सिबिलिटी, जो मेन जो ड्यूटी होती है वो IP की होती है, तो वो ही नोस कि कहाँ पे किस तरह का म्यूजिक है और कैसा उसको डांस करना है और किस तरह से IBC को मोर इफेक्टिव बनाया जाए. लेकिन सर अनफॉर्चुनेटली
you are very right, because you work at the ground level, you encounter
sir.
with the issues which are to be given answer either by the statute or by judiciary by making a suitable interpretation thereof. But if you see, you are under supervision of IBPI. You are
conflict of interest.
The regulated by that. So in the legislative process or in the drafting process or otherwise, no formal arrangement exists. Though a note is published and whosoever gives the suggestion gives, but it should be given, some process should be given that the mandatorily from this size of IPs or this body, there should be suggestions necessarily before a regulatory change or regulation is framed or law is amended. So there should be some, instead of consultative, it should be some mandatory process, and there so that effective participation can take place. Even the proceedings before the Standing Committee of Parliament on Finance, that is also an internal government to bodies explain their view. So we require more participative legislative process.
सर इसमें ममता जी मेरे साथ थोड़ा सा एग्री करेंगे, हम तो पार्टिसिपेट करने के लिए तैयार हैं IBB के साथ, मिनिस्ट्री ऑफ MCA के साथ आल्सो, लेकिन शायद उनकी तरफ से कुछ इनविटेशन की कमी है.
That is why I pointed out the statute should provide for mechanism. It should not be left to the mercy or discretion. Some necessary, those who are working on the ground, their feedback is the most necessary, because they come with so many situations, which in the case of Manish Jain or the settled principle, the legislature cannot provide for all possible situations and outcomes of a provision and eventualities. So certainly we have to we will have the gaps. Actions will precede, will be subsequent. Legislature will always be following the situations, cannot make up with the situations in advance, in anticipation. And a good law can only be that which anticipates most of the situations and prescribes for that.
थैंक यू वेरी मच सर. सर हमारा ना एक परवीन जी, हम एक ना अभी नेक्स्ट वीक के अंदर एक वेबिनार कर रहे हैं जिसमें हमारे निपुण जी स्पीकर हैं और मदान सर को भी हमने स्पीकर लिया है, जिसका टॉपिक है बेसिकली कि जो DC प्रोसीडिंग्स अगेंस्ट IPs के आ रही हैं. तो सर आप CA भी हो और हम आपको आई टेक लिबर्टी फ्रॉम प्रवीण जी, हम सर आपको इनवाइट करना चाहेंगे, तो प्लीज स्पेयर सम टाइम फॉर अस इफ पॉसिबल.
That part of the statute we have never read, in fact, because we refer to the matter to the IBBI in case, otherwise instead I would be a participant. It would be my because as a learning individual I will learn so many new things.
We are honored, sir. I am honored. Okay, sir. अब next पे move करते हैं. एक थोड़ा सा बड़ा एक controversial issue आ रहा है कि is co-borrower also guarantor? I explained to my colleagues in this way that let's presume कि एक CD ने 1000 करोड़ रुपया लिया हुआ है, उस 1000 करोड़ रुपए को जो भी उसके डायरेक्टर्स है, हस्बैंड, वाइफ, बच्चे, whosoever in the family, they have guaranteed. सॉरी, नॉट लाइक दिस कि जब उन्होंने किसी ने 1000 करोड़ रुपए लिया हुआ है तो 1000 करोड़ के केस में जनरली ये नहीं होता, ये छोटे केसेस में होता है जहां पे आप हाउसिंग लोन वगैरह लेते हो या एजुकेशन लोन वगैरह लेते हो या व्हीकल लोन वगैरह लेते हो, तो उस केस में यानी कि जो जिस भी सीडी ने लिया उसके साथ उसके जो डायरेक्टर्स हैं या गारंटर्स हैं उनको एज ए को बॉरोवर बना दिया गया है. तो कैन को बॉरोवर बी ए गारंटर और नॉट?
Independent of that arrangement?
Sir, उसमें जो उन्होंने
only in the respect of same loan agreement, loan transaction.
Same loan agreement, yes sir, same loan agreement. Mamta ji, please opinion on it.
So, what purpose it would serve? The property in any case of the same. Why it is the necessity that they should become guarantor as well?
सर उसकी पर्पस यही सर्व हो रहा है कि वो व्हाट इज हैपनिंग इज दैट कि अभी ये आईबीसी के अंदर जो नोटिफाई करा गया वो सिर्फ यही एक्सपेक्ट करा गया कि पर्सनल गंटो का कॉर्पोरेट डेटा, तो वो उनके अगेंस्ट केसेस फाइल कर रहे हैं, ट्रीटिंग देम एज पर्सनल गंटो.
Yeah,
Will those
by limited understanding of law, I don't think that they can be treated as guarantor if they are co-borrowers in terms of loan agreement specifically. And all if they whatever mortgage or security they have provided in the capacity of co-borrower, that should be binding on them too. They cannot be treated as a guarantor because guarantee arrangement, one person cannot, there are three parties, one COT, one creditor and one principal borrower in a guarantee as per 126. Here are only two parties. They cannot have, in my view, two different capacities for the same transaction. One arrangement itself is sufficient to take care of that transaction.
But this arrangement is restricting the
They are
right
not
of
a third
the
person.
lender.
They are not a third person. That is
They are
what
not
I
a
am
third
trying to
person.
say.
Exactly. That is why I highlighted this thing.
Unless there could be a situation. One more situation could be there. They are co-borrower to a limited amount in that broader arrangement, suppose, and for the higher amount they give a guarantee.
सर वही तो होता है हमेशा.
कि मान लीजिए बोरोवर है, एक ने 500 की लाइबिलिटी ली, एक ने 200 की ली, और एज ए गारंटर उसने 700 की दे दी या 500 की दे दी, more than what is there. Then that would differentiate between the. But if the amount is same, liability is same as a co-borrower, so nobody can be a third no guarantor in that case.
What my understanding of law is that in case of guarantee, a third party has to be involved. Definitely, a person can't give guarantee against himself. The moment he becomes a co-borrower because of any reason, then he can never be a guarantor. This is my understanding of law.
In the capacity of co-borrower, if he is having a limited liability, not to the whole amount of the loan, and for the loan amount exceeding his loan liability, the person can become a guarantor to the other co-borrower in respect of other co-borrower who is having an independent liability other than this one. That can be a possible view.
Thank you, sir. Thank you.
Banuji,
Yeah.
I think
Yes.
5 minutes और ले लीजिए, then we will advocate.
सर हमारे को हर पॉइंट पे इतना लाइटन कर रहे हैं. इनफैक्ट आई एम फीलिंग प्राउड कि मेरे जो पॉइंट्स आ रहे हैं इसके अंदर वो इतने यानी कि प्रैक्टिकल इतने हैं कि उसके ऊपर सर हमारे को अनलाइटन कर रहे हैं. एंड निपुण जी, आई यू कैन आल्सो ओपिनियन ऑन दैट, बट एज इंस्ट्रक्टेड बाय ममता जी, आई विल फिनिशिंग विद इन 5 मिनट्स. मेरी तो अभी कितनी स्लाइड्स हैं? Oh my God, अभी तो 16 स्लाइड्स हैं. It is more than 50 slides.
Sir, you may continue, sir. I will come in wherever needed, sir. You may continue.
Sir, ममता जी की इंस्ट्रक्शन है 5 मिनट, तो I have to follow her instructions. चलिए, जैसा भी कंफर्टेबल रहेगा, we go and try to conclude it also, because प्रवीण जी भी कहेंगे कि हमने आपको जो टाइम स्लॉट दिया था, you are exceeding that. Okay, I try to move a little bit faster. Can debtor replace RP?
I am going to on mute mode.
That will unmute our mind also, because we won't be learning, and we are here to learn from you, and it's a really प्रवीण जी ने हमारे को एक बहुत अच्छी अपॉर्चुनिटी दी है आपसे सीखने के लिए. सर प्लीज carry on. Section 98 gives power to debtor to replace RP. In my opinion, it is a very conflicting sort of situation, because अगर हम पैरेलल प्रिजन COC के अंदर भी देखें, वहां पे भी तो 2/3 की फाइनेंशियल क्रेडिटर्स को रिक्वायरमेंट होती है, और वहां पे किसी भी उसको डेक्टर्स को, जब सस्पेंडेड डेक्टर को कोई ऐसी पावर नहीं है. बट इन दिस केस देयर इज अ पावर. This is practically what we do planning before CRIP. I'm just moving a little bit fast for that. Without reading it takes a lot of time. जब मैं PPT सब साथ शेयर करूंगा तो हमारे सब पार्टिसिपेंट्स इसको पढ़ सकते हैं. These are absolutely practical aspects. अगर आप अपनी 94 की एप्लीकेशन बना रहे हैं तो इन चीजों को आपको ध्यान देना पड़ेगा, तभी आप अपने क्लाइंट का फायदा कर सकते हैं. या आपके जैसे अगर 95 की एप्लीकेशन आ गई, you have to manage all these things. Even there are certain points कि आपको क्रिप के अंदर भी कुछ चीजें मैनेज करनी पड़ेगी। ये कंट्रीब्यूशन है ममता जी की, और स्पेशली ये जो जितने पॉइंट्स हैं उनकी कंट्रीब्यूशन इसके अंदर ज्यादा है। तो आई एम रियली थैंकफुल टू हर कि उनका जो वास्ट एक्सपीरियंस है, बिकॉज शी इज द फर्स्ट आईपी इन इंडियन हिस्ट्री, और फर्स्ट ही इन्होंने केस करा था आईबीसी का। तो टिल डेट वी कॉल हर द मोस्ट एक्सपीरियंस आईपी एंड नाउ एडवोकेट आल्सो।
That's perfectly true.
It's an honor to get that from you. Thank you so much.
These are some excluded assets. You can go through application. We have already discussed it at quite length कि ये कहाँ पे कैसे फाइल होगी, तो accordingly this is there. जब हम लोग फॉर्म ए फाइल करते हैं डेटा सेक्शन 94 के अंदर, तो उसके अंदर क्या क्या ये उसके फीचर है, that I am noted on for the benefit of my colleagues. 95 के अंदर जब प्रेफरेंशियल कैटर एप्लीकेशन फाइल करता है, उसके अंदर क्या क्या प्रोसीजरल एस्पेक्ट है, that I have noted down. तो मैं पीपीटी शेयर करूंगा, तो you can go through it.
Yes.
These are the important sections which in my opinion were required to be read very deeply, जो already हमने करे हैं। सर इसके अंदर एक बड़ा अजीब सी सिचुएशन है कि हम पर्सनल रेंटर के केस में डेटर वर्ड्स we are using at many places, और ये ललित कुमार जैन के केस में ये क्या कहते हैं एडवोकेट्स ने कहा भी था, उनका एक ग्राउंड भी था, लेकिन इस डाटा वर्ड को ना रेगुलेशन में, ना रूल में, और ना ही एक्ट के अंदर डिफाइन करा गया। तो सर एनी वन ऑफ अस वुड लाइक टू enlighten me on this?
Section 37 of the IBC you will have to resort to, because the definitions which have certain acts are given. Otherwise, in the common parlance, whatever is the understanding of a debtor in accounting, or that would in the commercial world, as it is understood in general, will have to be resorted dictionary meaning if it not defined. If it is defined in those acts which are specified in section 33 subsection 37 of IBC 2016, then you can borrow the definition from those places.
Sir is absolutely, I mean, I think sir has already drunk the whole IBC code, it seems. Knows it by heart. So it is sections for the benefit of all very quickly, 337, 3 by 37. It absolutely categorically mentions what sir has mentioned. Words and expressions used but not defined in this code, but defined in the Indian Contract Act, the Partnership Act, the SCRA Act, the SEBI Act, and the Recovery of Debts Act, the LLP Act, and the Companies Act shall have the meanings respectively assigned to them in those acts. तो आपको अगर यहाँ पे कोई मीनिंग नहीं मिलता है, but if it has been defined in those acts which we mentioned in 337, then we have to pick it up from there. Thank you, Gupta ji. Manoj ji, then
I'm moving forward. Yeah, please. If you want, I can close it down right now. Please.
एक बार निपुण जी को दे देते हैं.
हाँ जी.
सर
निपुण जी प्लीज.
सर आप प्रोसीड करिए, मैं ऐड कर रहा हूँ सर, टाइम टू टाइम, डोंट वरी सर.
नहीं निपुण जी,
we are going fine with the flow. Mamta ji, do you want me to speak on anything specific?
Yes, Manoj ji and we were all also very keen, and so was Parveen ji and the entire team. I'm sure Mr. Gupta will also like to hear you. There was one particular query that was doing rounds in our mind, that in this personal insolvency, it may so happen that when the claims are getting filed, say for example, few bankers don't file the claim because of whatever reasons. Now, when this personal guarantor gets resolved with his debts, the people who have not filed, or the creditors who have not filed their claims, against them also, will the personal guarantor get a clarity, which means get a clean slate, or will their claims still hang around his neck? We would like to know this, because I think this is a very tense topic. Yes, Manoj ji and Nipun ji.
Yeah, that will remain hang. और अगर किसी का रीपेमेंट प्लान के अंदर या रजिस्ट्रेशन प्लान के अंदर उसका कुछ नाम नहीं आता, वो नाम तभी आएगा जब अपना क्लेम फाइल करेगा, तो वो दोबारा पर्सनल गारंटी रिवोक कर सकता है, 95 की एप्लीकेशन फाइल कर सकता है। सर प्लीज आप मेरे को भी एनलाइटन कर दीजिए फर्दर।
क्लीन स्लेट का कॉन्सेप्ट ही मतलब डावाडोल हो रहा है सर। गुप्ता जी प्लीज बताएं, एंड देन निपुण जी आई विल
let Nipun should take the first thing, because once
Please.
in my estoppel or something should come once you are aware the proceedings are in RAM and everyone is aware of that.
Right.
And if you don't exercise your rights, how you will explain the inaction on your part? The
Yes.
judiciary may not, judicial acceptance may not be there for that application. If you have missed the bus, you have missed the bus. Legally, other recourse may remain under other law. If there is a law, that is my understanding, limited understanding, but I will have to study further on that. The right to file a section 7 remains if you don't file the claim.
So, sir, I agree with what Gupta sir is saying. I have a difference of view with respect to personal guarantors. Now, let us assume one situation wherein during the CIRP, one financial creditor has not filed a claim. So if he has not filed the claim, and if there is a resolution plan, and then we can very safely rely on Ghanshyam Mishra, and the claim goes away. That is what the logic of clean slate qua company is there. Now the question comes with regard to personal guarantor. If that claim is not filed, let us think that a situation where claim is not filed, what we as a guarantor, or we let's say as an advisor to the guarantor can do. My view is like it was happening. In fact, Gupta sir is aware in some of the cases what was happening when personal guarantor used to file insolvency petition so that his assets are not sold, his let's say residential property or shops or in the personal names are not sold. What we used to do is we used to file our insolvency through directly by a personal guarantor. Now some of the NBFCs or some of the banks, they were saying you have just filed, we are not bound by your interim moratorium, and they used to proceed. So what we used to do is we filed an application making that particular financial creditor as a party and getting a specific order that they cannot proceed. So in my view, suppose a financial creditor is assuming not filed and I want to protect myself, it is better that I make him a party and move an application, because we have to end the story and start again. So if we do not do it in wholesome, then we are
That's
left
a practical way of getting get certainty about all these issues. That's because they are a necessary party or proper party make in the petition, and then their right will be closed.
Correct. So that is a probable solution, Mamtaji, which I can think of, and which practically we have done it, and we have got orders from the bench prohibiting the creditors who even are not having this much duty to come and file a claim or lodging a claim or moving an application, and thereafter they are coming.
But why? Okay, we understand that. Just maybe a thread out of it. Why is it that the law did not provide? Because after all, a human being will have that many assets. He will not be able to get assets from the sky once it is resolved. So why is it that here we did not discuss about the clean slate provisions as we have in other insolvency law part? I
think probably that will also get evolved, and I always say it's an evolving law and it's a revolving law. Whatever you decide today may not be a good law tomorrow. It always happens in IBC. In fact, I remember. In fact, there is a very interesting case. I hope of Rakesh Agarwal, if you have read NCLAT order, when Section 10 was filed, he was eligible to buy the company back. But by the time 29A came, he became ineligible. Then nobody came forward to buy. Company went under liquidation. At the time of liquidation also, he was ineligible because of 29A. But subsequently, MSME amendment came and he became eligible.
Correct. I know.
He became eligible, but he could not again when he filed. So NCLT Ahmedabad bench took a view that no, you can't do it. Then the matter went into NCLAT, and when NCLAT reversed the order.
Allowed because
Allowed. They say that only at the time of filing of the scheme, it has to be checked. If
Yes, yes.
somebody was not eligible, but today is eligible, you give him a long rope.
When there is when at the proximate time to the effective decision making, it should be the law. You can't bar. But that means at the time of filing that subsequently he cannot rectify. That is not a logical view.
Yes.
That's not a logical view. Even under section 30 subsection 4, if you see 29 AC, the COC is empowered. Proviso, second proviso there too, empowered to give time to the resolution applicant to rectify the and eligible in section 29 AC 30 days, and that will not be counted in section 12 also.
Yes, sir. Absolutely, sir.
In fact, in ineligibility, I remember, sir, when I was appearing in SR Steel matter, the issue was that they both were disqualified in the first round. New Metal was disqualified because it had some relationship with the promoter group, and ArcelorMittal was disqualified because that there were two NPA accounts which were their related party, Uttam Galwa and KSS Petro. So they said that you rectify it and you can come back again. Supreme Court said so.
7,500 crore.
So they only paid 7,000 crores to get an entry ticket to be eligible to do a voting.
Yes.
That was the argument in the court. I was there in Supreme Court. They said they have just got a ticket after paying 7,000 crores. And the promoter said, I am ready to pay more than 12,000 crores. Though ultimately it got rejected because of 29A. But yes, this was a very good argument that they are only eligible because disqualification is removed by making the payment and making NPA a performing asset.
And that too under power under Article 142.
Yes, yes.
Not under section 29A because the time had already expired.
Yes.
And you see in the MBL infrastructure judgment.
Yes, sir. I was about to say that.
Again, the same thing has happened because it has been implemented. They have utilized that. Ultimately, the maximization of value of per vote editor principle has come in therein. So all the frivolous applications objecting to the resolution plans on ground of section 29A should be dismissed.
Right, sir. Right, sir.
सर मैं तो इसमें एक ही बात कहूंगा कि अगर ये इस तरह के लूप होल्स या इस तरह की शॉर्टकमिंग्स ना होती एक्ट में तो शायद हम ये वेबिनार भी ना कर रहे होते और शायद हम एक दूसरे के साथ डिस्कशन भी ना कर रहे होते और ममता जी और निपुण जी शायद जुडिशरी में आपको इस तरह की शॉर्टकमिंग्स दे के एम्प्लॉयमेंट दी हुई है. You should be thankful to them. On the lighter side.
We have to see overall interest of the country first.
Yes, sir. Yes, sir. Yes, sir.
And you see section 29A, the greatest fallacy. What is the greatest fallacy? After the implementation of resolution plan, after 6 months, the promoter can come back. There is no restriction.
Yes.
So rather, you are making CD as a trading asset by virtue of this lacuna, as well as making an ARCs eligible to bid.
I understand.
You are not going into the resolution of insolvency in that sense. Recovery in substance and is the in sum and substance is the that you can say mantra
has become the objective. In fact, so you're bang absolutely on the point because BLRC report, gentlemen and ladies and esteemed participants, if one actually reads the BLRC report and even the objective of the law, what Shri Gupta said is absolutely very much actually relevant. That somewhere probably we've, I don't know, just do not want to say it, the exact words that is coming in the mind, but we need to focus on the objective of the code, I think, going forward. Nipuji, one more question and then maybe we'll just open it for 5 minutes question and answer. There was one case which was encountered by our dear President Manoj ji that we would just like to get a fair understanding. For example, there's a personal guarantor, Mr. A. He may have given guarantee to 10 different places with 10 different bankers and for maybe 10 different accounts. He has 10 companies in which he's in the board. Now, in one, the personal guarantee is definitely for all. He cannot be chosen for A company, B company, C company separately. So how does it actually happen? Does the A company's lenders will file only to the extent of
their dues?
Their dues, right. And then what remains behind, how is that to be dealt with? Manoj, if you can actually narrate your real life example and where we were...
Yeah. Thank you very much. Actually, what happened in one of my case, there were 5 grantors. 250 करोड़ रुपए का उनकी गारंटी का उन्होंने अमाउंट दिया हुआ था। तो जब उन्होंने यानी कि मेरे को जब उनकी वो रीपेमेंट प्लान उनकी फाइल करनी थी, जब उनका जब क्लेम आया बैंक का मेरे पास, तो बैंक ने ये करा 250 करोड़ रुपए का क्लेम 5 गारंटर के अगेंस्ट फाइल कर दिया। एंड आई वाज ऑफ द ओपिनियन कि आप जो ये 250 करोड़ का क्लेम है, इसको 5 में डिवाइड करके जो भी 50 करोड़ पे आता है, इसको इस तरह से आप फाइल करो, जहाँ यू नो एज ए आरपी आई वाज ड्यूटी बाउंड कि अगर उन्होंने 250 करोड़ का क्लेम फाइल करा भी है, तो आई शुड रिस्ट्रिक्ट इट टू द 50 करोड़ ओनली, बिकॉज इन टोटलिटी टोटल 250 करोड़ रुपए का क्लेम है। तो ये एक प्रैक्टिकल सिचुएशन आई थी। अब प्लीज एनलाइटन अस ऑन 250 करोड़ रुपए का एक इंडिविजुअल के अगेंस्ट क्लेम होगा, जब 50 करोड़ रुपए का उस इंडिविजुअल के अगेंस्ट क्लेम होगा। रश्मि जी, प्लीज यू आल्सो एनलाइटन अस, यू आर आल्सो वर्किंग वेरी हार्ड इन दिस यू नो आईबीसी, एंड अदर मेंबर्स कैन आल्सो एनलाइटन अस कि कैसे करेंगे हम इसको।
I'm looking forward for an answer from you, or from the panelist only.
Gupta sir, would you like to?
Liability of a guarantor is limited to the extent he has subscribed to. It's not beyond that. If 250 crores out, if I have taken 50 crores liability, it will be restricted to that only. You can't fasten more than what he has committed to legally.
I think I was not able to convey properly. What I mean to say is that
Yes.
कि एक 250 करोड़ रुपए का उसका डेट आउटस्टैंडिंग था, उसके 5 गारंटर थे, पांचों गारंटर ने 250 करोड़ रुपए की लायबिलिटी थी।
Then any one of them or either they can be they can 250 crore. That doesn't mean it become 1250 crores, but they have taken jointly and severally liability
yes.
to pay 250 crores. So any action can be taken against one individual guarantor or all the guarantors. But there cannot be a situation you can't, if you have recovered 50 crores from one guarantor, so you can recover only 200 crores from other guarantors. You have recovered 250 crores from guarantor, you cannot recover any penny from other co-guarantors, co-securities.
Because unjust enrichment to nahi kar sakte aap.
You can't. They're legally not possible. That provisions of law are also very clear. And if we go into different provisions and rights and obligations of securities in the Contract Act itself, it is given in some of the provisions. I do not remember exactly the section is.
So claim will be
sir,
that amount on each, but recovery will be to the extent of.
What I did is that in that case, I accepted claim of each individual 250 crore rupees. I might have done wrong also, but at the same time, accepting of claim, I have given a proviso that jointly with others, this amount can't exceed 250 crores.
Yes, that is you have done rightly. After making this,
thank you very much, sir. Thank you very much, sir. Thank you.
Making your mindset very clear. This is subject to this condition.
Right.
Thank you. It means at least I'm a learned person. Thank you very much.
What about the claim of other companies? मतलब like Mamta ji just said ना कि if personal आपने एक company का claim को देख लिया और जो बाकी companies के claim थे because he's a personal guarantor to other companies also, then will those companies also file?
देखिए वो कंपनी भी फाइल करेगी, फाइल करेगा बैंकर लेंडर जिसने उन कंपनीज को दिया हुआ है, तो वहां पे भी ये सेम सिचुएशन आएगी। अब सपोज कर लो मैंने ए लिमिटेड का आपको बता दिया, अब बी लिमिटेड के केस में भी उन्होंने गारंटी दी हुई है, तो वहां पे 200 करोड़ की गारंटी है, तो वो यानी कि 40-40 करोड़ रुपए की आएगी। लेकिन जब उसका मैं क्लेम उस पर मान के चलो एक ही लेंडर है, स्टेट बैंक ऑफ इंडिया है, जिन्होंने दोनों कंपनीज के लिए मेरे अगेंस्ट क्लेम फाइल करा, तो मैं यही करूंगा कि मैं उनका 250 प्लस 200 450 करोड़ रुपए का क्लेम फाइल करूंगा विद द प्रोविजो कि इट कांट एक्सीड नंबर 1 फॉर वन कंपनी 250, फॉर नंबर 2 फॉर सेकंड कंपनी 200 करोड़ रुपीज जॉइंटली विद अदर्स।
Thank you so much. I think we are now.
Yeah.
Yes. We're now moving towards the closure of the session. Rashmi, would
yes,
you?
Please.
Rashmi, would you do the honors by giving a vote of thanks to everyone?
Just 2 points I would like to add.
Yes, sir. Yes.
We have to be as far as the letter. There should be a difference of the letter of assurance or letter of comfort versus guarantee.
Okay.
If it is a letter of comfort or assurance, it will not amount to guarantee. It cannot be enforced by a lender.
Correct.
Just generally as a parent company, we assure that it is our practice that we don't allow the subsidiaries to default, or generally vague, which is not a legally binding obligation. Such a letter of comfort cannot be treated as guarantee and cannot be enforced at law.
Yes.
And other point is that as far as the delegated legislation is concerned, if we read section 196 1T or 240 with 469 bracket में 2 of Companies Act,
Yes, sir.
there is a wide difference. In 469 2, much wider delegated legislative powers have been given to the government as compared to, and our regulations are also subject to rules by the central government.
Right.
So in IBC, regulations cannot be in contravention to the substantive provisions of law as well as to the rules which are
Right.
framed by the central government. So, and IBBI in most of the cases is exceeding its jurisdiction.
Right, sir. Even we see that in Ministry of Corporate Affairs, specifically the beneficial interest rules, sir. That is very, very
because
stark.
this is a as a judicial person, I would say this is it is setting a wrong precedent in a sense that the parliamentary scrutiny to a provision is see an example of section 33(3)
Yes,
of
sir.
IBC.
Yes, sir.
Non-implementation, what the rights of a person. He can force for non-implementation the liquidation, and simultaneously if you see regulation, if I am correct, 39(9) is which of CIRP regulations.
Yes, yes, the new one. Yes, sir.
So both are in direct conflict with each other, which you have to. A creditor is an aggrieved party. Whether he should go under section 39(9) or whether the provisions of section 33(3) should prevail.
Yes, sir. Yes,
So,
sir.
so there are so many aspects which need to be considered.
And we can, actually what Mr. Shri Gupta ji said is right. And sometimes, we as professionals lose sight of it because we are not looking at things holistically.
One great tragedy that you can't read. You will, everyone, whether it is a judicial officer or whether it is a practitioner, will miss the things. If we don't, in the current scenario, if we don't read IBC as well as regulations together.
Right.
Latest, I would just try to, I'm trying to write an article on this latest decision, where the operational debt less license fee will be treated as a operational debt, larger bank.
Yes, sir.
That view, I think I took in first of 3 orders when I joined in Kolkata. It will be ignoring the Mumbai bench decision. But even if we have seen the 5 larger bench consisting of 5 honorable judges, they have not referred to section 513 clause E or clause C, and regulation 31 and 32 are a consequence of 513 clause E.
Absolutely.
And operational debt will come in the earlier clause of 51C. It is a part of the business expense.
Yes, sir.
So even the counselors or advocates, with due regards, they are not updating themselves in a sense to assist the bench, and because what is happening, still there can be a controversy because we are relying on a regulation which is input or direct or explanation, which is not relevant. All the expenses relating to the operational debt will fall in the business expense itself. If I am having a personal property, paying for that will not form in 513. So that is the differentiation. But in recent decision, I was sorry to miss that even the judges or the counsels appearing, they did not assist the bench in that direction.
Thank you, thank you.
Sir, I am in simply awe, sir. जिस तरीका से आपने मतलब एक section and एक law का point लेकर explain किया है. We have much more learnings to do from you, and I'll request Praveen ji के एक session आपके संग करे ताकि with so much intricacies and laws and acts को थोड़ा लेकर के साथ में पढ़ना और उसको समझना और फिर law के angle से भी उसको देखना. There is so much to learn from you, sir.
And it's all because of I always feel I'm like a pen. Whatever Krishna wants to write through me, I write. I'm not the doer. And I would request my phone number and connects are available with Praveen ji. Everyone is anytime, every time welcome. Because I would be in that process benefiting myself, enriching my knowledge, understanding of law.
नहीं सर, वी आर मच, मतलब आपने ये अपॉर्चुनिटी दिया है तो हम इसका फायदा जरूर उठाएंगे और आपको जरूर तंग करेंगे सर whenever we are stuck with something.
It would be a great opportunity for me to remain relevant, though I am starting my own, but it would be always a great opportunity to remain relevant in the field of law. I am a student of law, still learning, and will continue till I die.
I would like to extend on behalf of JIPA organization a big thanks to our Honorable Shri Virender Gupta ji for taking out his time for this webinar and guiding us with his experience and the way he detailed deliberation on each and every point from the adjudicating authorities point of view, from the law point of view, from each and every section as quoted by him. It is I have been just struck by awe, and the whole all the participants who are hearing this today is actually getting benefited a lot from this session. I'm also thankful to our panelists, Dr. Mamta Binani, Mr. Nipun Singhvi, Mr. Manoj Anandji, for such a nice deliberation and a wonderful session on how Manoj ji has prepared an PPT and Nipun ji has given, his suggestions wherever he found it necessary. And the most important point has been taken care of as the limitation thing. And then how the other things which has been recorded, all the points have been, I think, taken care of, and there's still as Nipunji had rightly said, it's a evolving law, so we need to see ki kya isme aur nikalta hai. And then I'll request Praveen ji to have some more such sessions on this, and so that we are continue on the same panel. And and Praveen ji, aap kuch bolna chahenge to you are most welcome.
Thanks, Rashmi ji. I am very much thankful to Virender Gupta ji, who have explained very nicely word to word, law to law, regulations, and all those. And to our panelist, Mamta Binani ji, Nipun ji, Mukul ji, Manoj ji, and especially Rashmi ji and Neha ji, who will organize very efficiently, and our participants to contribute their valuable times. Thanks a lot. We will in touch for further upcoming webinars. Thank you, sir. Thank you.
Thank you so much. Thank you.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you,
Thank you, sir.
Thank you so much.
Thank you, sir.
Thank you. Thank you so much.
कर लेना 12 आदमी है जब दे होस्ट को एंड कर लेकर दिए